Yes.
Adjournment request, if any, from item number 1 to 17.
वो पूरा बैग को इधर दे दो, उतना दूर से कहां लेके? 1 second. My tools should be within reach. Yes.
My lords, I'd like to mention item number 8 of the daily list. We were supposed to file an IA and it was duly filed, but yesterday
I've informed the other side.
no, my lord. But the thing is,
Then you'll have to wait
there
for
is a
the case to be
typographical
called.
error. So this IA
It doesn't matter.
Yeah.
If you have not informed the other side, wait for your turn. Kashi is here.
Respondent search. Respondent number 5, 6.
He wants time. We are giving him time. As
we'll file
wait
a
for.
new IA, fresh IA, because it has a typographical error.
Ajay, you want to withdraw this?
Yes, yes,
Then you don't need to seek any permission.
yes, yes.
Um,
There is a. We were supposed.
what
to
is your
file-
name?
N. Gogoi on behalf of M. Sarania.
Gogoi. Mr. M. Gogoi.
N, my lord.
Mr. N. Gogoi, learned advocate, on instructions from Mr. M. Saranya, the learned advocate on record seeks permission to withdraw the aforenoted interlocutory application number 969 of 2026 in order to enable the applicant to file a fresh, properly drafted interlocutory application. The prayer is acceded to. The application is permitted to be, is dismissed as withdrawn with the liberty aforesaid.
My lord, the date is fixed after the.
Please file your petition then. You're asking for so many things in advance.
Okay, my lord, fine.
Normally, it could have been, the prayer could have been opposed by the other side, that whatever you have filed, please stick to it. Don't make changes. We don't give opportunities of plugging the loopholes. And you're asking for a date also. Huh?
Obliged, my lord.
Yes.
From item number 18 to 30.
Lordships, I beg to mention item number 19 of the daily list.
Adjournment
Lordship,
slip
with the
circulated. All right.
consent of the other party.
All right.
Anyone for item number 22 and 23? Adjournment. Yeah.
Adjournment slip circulated. Give a date.
Yes, Lord. 15-6.
My lords, there is only one submission to be made, my lords. In terms of the last order, the Honorable Single Judge, the amount was allowed to be paid, my lords, and they have paid. But that if I accept that amount, my lords, from the controlling authority.
What do you want? You want adjournment? We are giving you adjournment.
My lords, I'm not seeking for examination.
Which item?
Item 22 and 23. my lords.
Adjournment slip has been circulated. If you have not given, if you have objected, we shall hear the matter. But we can't without the records.
No.
Why do we accept any submission?
My lord, in the evening, I got a call from the associate that the adjournment will be rejected by them. They will appear in this matter.
Who tells you? Who tells you all this?
I got a call from the associate
Sorry,
of the,
adjournment slip circulated. Adjourn to. We can give you an early date.
my lord.
Port May 4-5.
GPO.
Request.
Lordship, with respect to item 20, I'm praying to call for an additional affidavit. I'm seeking to call for an additional affidavit.
You have already filed.
We have filed, Lordship.
Please bring it.
Okay.
May I please, Lordship, I beg to mention item number 30. Lordship.
1-3.
Lordship.
13.
Lordship.
Hmm.
Lordship, on last date, the further instruction from the appellant about the other 6 terminated employees were remained. Lordship, I have informed the
Item
other
number
side.
13.
30. 30.
30. Yes.
Lordship, we need a short passover for the day. because the instruction from the appellant is still remain. Lordship, I have informed the other side also.
As prayed for on behalf, you appear for the government advocate Assam. Or you're for the appellant? You're for the appellant.
Appellant.
As prayed for. Mr. Bhuya, any problem?
No, my lord.
As prayed for on behalf of the appellant,
No.
re-notify sometimes in June.
11 June.
May I please, your lordship? My lord, I beg to mention for listing of, my lord, two matters, my lord. Regarding that Qazi's, my lord, those, my lordship has already heard. my lord.
You mentioned after the Bihu holidays.
That will be home, my lord.
The Qazi, this
what has
institution which has been removed by the
Remove,
new
my lord,
amendment.
But new law has been come into force, but no person has been appointed for the purpose of.
All right, you
registration.
mentioned on 20th, we'll see what date to fix.
My lord.
Chalo.
Oblige.
Daily list for orders item 1.
First time, right?
Also, there is an application for explanation of delay of 478 things, your lordship.
You want to file your response?
Yes, sir.
We
We
have
have
filed
filed
it.
your lordship.
You have already filed it.
We have filed the counter, your lordship. Your lordship, my only submission is that they have not mentioned any sufficient reason, any sufficient.
No, we are finding some reason because it
is
was
just
during the contempt
understand.
application that
Lord,
the matter was delayed.
delay, lordship.
Your lordship,
Because
in
we
this,
filed a review earlier, lordship, if I may be able to narrate the facts, your lord.
yes.
Gauraji, take the order from. The delay is condoned.
If the court is allowed, your lordship, I just want to mention this thing that the learned trial court in the title suit number 166 of 2022 is deliberately giving the date of the 2 months.
We can't look into this submission
Lord.
now. Mention when the case is called up, when the appeal is processed. Appeal to be processed.
Your lordship, but we are not all, we are not, we are not any, we are not doing any construction also in the
Lordship,
title.
listen in the appeal.
We'll have a appeal listed and heard immediately.
Lord,
Okay.
17/6
17th of,
June.
lordship, some date in May, your lord.
Appeal to be processed. No.
No, May, June, no.
Ah.
Lord.
No, not June. We will do it, we will have the appeal processed sometimes in first week of May.
Lord,
478 days delay,
Lord.
only for that reason. On merits, we have not gone. What is
Any
the
Friday,
merit?
your lordship,
Huh?
any Friday.
8 May.
Lord.
8th of May.
Lord.
Why have you chosen Friday?
Your lordship, I will come from Delhi actually, your lordship, so.
That is
I
no
don't
ground.
want to
But
be
anyway,
free
we
after
accede to
when-
your
when-
request.
Lord.
Court, your
8
lordship.
May.
8th of May.
Lord.
Deeply obliged.
Item number 2.
May it please your lordship.
Yes, yeah.
The opposite sides were about to file their objection, your lordship.
Um,
They have not filed yet. Lordship will file our objection. Actually, we have no objection, lordship, in that case. They're for delay continuance.
All right. Delay condoned, appeal to be processed. Date sometimes in June, July.
Like,
22nd June.
ये तो लिख के ले आता है.
Item 3.
Go to him to take the dictation. Don't write on your own. Yes.
The appellants were supposed to file their affidavit in reply.
For 19 days delay.
They were supposed
Nobody
to,
is here.
they were supposed to file their affidavit.
Who was supposed to file an affidavit? क्या बोलते हैं पता नहीं चलता.
Already we have filed a response to the.
But the applicant should be here, no?
Yes, yes.
Nobody appears on behalf of the applicant to press this application. The counsel for the respondent is present. Let this matter come up for consideration on next week under the same heading.
8 April. Item 4.
Lordship, in this case, Lordship, the service upon the respondent number 4 is complete as per Lodima Court's.
You are appearing for respondent number
Yes, sir.
4. What do you have to say?
I have responded, lordship.
You'd like to file counter affidavit. So and so learned advocate has appeared on behalf of respondent number 4. And
Yes, your lordship.
Full litigation,
Oh, who?
Who appears for respondent
Respondent
number
number four, Lordship, service is.
four? Awaiting the appearance of respondent number 4 in the
Lordship,
matter.
already, Lordship, may I kindly see the.
Just a minute. Awaiting the appearance of respondent. You're in a great hurry. We dismiss the petition. Unless the other side comes and explains or says nothing. So we are only asking, we know there is a tracking report that he has been served.
Lordship, I will be allowed to take justice service upon the respondent number 4.
He's been served, Mr. Counsel. If you're in a great hurry, let us put a decent burial to this case.
Lordship, I beg apology.
I don't appreciate of this kind of, over enthusiasm. Correct? Awaiting the appearance of respondent number 4. In this matter to contest the application, the matter is adjourned. This case is adjourned to give a date sometimes in May.
15 May.
In the meantime, the other respondents may file their response in case they seek to oppose the prayer for condonation or delay of 125 days in preferring the appeal. Correct?
Problem.
Normally, we condone such delay, but the private respondent must come here.
Lordship,
If he doesn't come despite this latitude, then we'll condone the delay.
Lordship,
Chali, next.
matter was made CIV for 9 months, 15 days. Lordship.
Next.
Item 5.
May it please the Lordship.
Who appears?
No, for respondent number 2, my lord, I am appealing.
For the petitioner, nobody appears for the, let this matter come up for consideration in July.
15 July. Item 6. Same.
Yeah. 5 and 6 is the same. All right. 7 क्या?
Item 7.
3 and 4. देखा ना?
Wait, please, your lordship.
Awaiting the report regarding service of notice on response number 1, 3 and 4. The matter is adjourned to June.
Obliged.
24 June. Item 9.
Yeah.
May it please the Lordship.
For the reason, you don't require to annex the letters and all. Just a statement was good enough. For the reasons stated in the application, the good grounds have been made out for restoring the case. The case is restored to its original file. IAS stands allowed.
Oblige, your Lordship.
Item 10.
A delay of 203 days.
Notice Jagan.
Milord, dusty service, all are the, Milord, employees of
But then notice has to go, no?
dusty, Milord. It will help.
That's the notice to response number. Respond
One.
number 1.
And there are, Milord, pro forma respondents also.
So we'll not necessary. Respond number 1.
Absolutely, fine.
Notice to respond number 1, both modes returnable, so.
Highly obliged.
15 June.
June.
Can it be on May, Milord?
May.
It's a dusty, Milord.
That's the notice also.
Highly obliged.
25/5.
Much obliged.
Supplementary list. Item 31 for orders.
Yeah, yes, no. 31 days. But other side has to be noticed, no? Nobody appears to press this application. Let this application be listed under the same heading on your date in the next week.
7/4. Daily list. Item 11 for admission.
Yes.
I'm appearing for the respondents, your lordship.
Yes.
I have filed the wakalatnama today. I do not even have the copy of the appeal, your memo, your lordship. Let me fix it after the vacation, your lordship, in the meeting.
Mr. What is your name? Mr. Y.S. Manan, learned advocate, has appeared on behalf of the respondents and submits that the learned counsel for the appellant be asked to furnish a copy of the brief to him, for him to respond, furnish a copy of the brief, for him to respond to this appeal. Stop. He would also consider the necessity of filing a response affidavit in case the same is required. Stop. For the aforesaid purpose, he seeks a short adjournment. Let this case be listed under the appropriate heading in July.
Interim order till such time is there.
Interim order, if any, in the meanwhile shall continue.
Lordship, since
Give him a
there's
copy of the brief
there's
today.
since there's an interim order, can it be a little bit earlier? Your lordship?
June,
What?
last week of June, give a date.
Yes. 26 June.
We have stayed the operation of the judgment, no? Be ready, we can decide it now.
25 June.
The law is against you.
That is up to you, lordship. I cannot, but when I argue the matter, then you got.
All right. But the these views are very, very tentative. It can change by the hour. No, May would be too early. May, we have fixed many matters
Last week
of June. Yes.
of that.
14 June. Item 12.
This appeal preferred by Union of India, my lord. Last occasion, my lord, the main ground of my lord, allowing the petition in favor of the petitioner was my lord, only in the summary security force court proceeding. The presiding officer was acted as an interpreter, but that's provide the rule 134(2) of the BSF Act itself. BSF rule itself provided that, my lord. So, my lord, that was there, my lord, ground in the writ petition that was replied in our affidavit, my lord.
Just a minute, give us a minute.
Right.
You don't state about the facts. You are raising an argument. You make an argument which you are only understanding yourself. We have not been able to understand head or tail of the case. I mean, is this the way you argue an appeal?
Well,
On behalf of the government? On behalf of the organization? What happened? What did the learned single judge do? You presume that we know about the facts in its entirety. Is it correct?
alia listed, my lord.
At least argue. But wait, let us go through the judgment. What you have said, I did not follow. You must have uttered 5 lines or 10 lines. We did not get a hang of it. Somebody security force. Is Mr. Parashar? They pleaded guilty only to the cocking of the rifle. Yes,
Well, the repetition was a constable in DSF. He was found sleeping in his duty post. And when called by the immediate senior, he threatened his immediate senior and cocked his rifle. Accordingly, 4 charges were brought against him. He pleaded guilty of charge number 1, 2, and 4. And regarding charge number 3, he not pleaded guilty and was not proved. When he pleaded guilty, all the rules were followed, the summary securities post court, and he was removed from service. Now, when he challenged before the honorable single judge, the main ground of allowing the repetition in favor of the petitioner is that the commanding officer was acted as an interpreter. And regarding the pleaded guilty, he being the interpreter and presiding officer, the same person, and pleaded guilty or not, that was not looked into, and repetition was allowed only on the main ground. That, but the rule, BSF rule 134(2) provides that.
shows the rule 134.
BSF Act.
Yes, sir.
Rule 134 within bracket 2.
These are border security force rules.
My lord. Rule 134 bracket 2. 134 evidence when to be translated, my lord. 2, the court shall for the purpose either appoint an interpreter or shall itself.
What language did he speak? Deven Sinha.
My lord.
He would be knowing Hindi.
My lord.
And this summary court, force court was
My lord, at that time.
a Hindi speaking person.
No, my lord, not he is northeast from my lord Barakbali. He's a Manipuri Manipuri.
Who?
Devan Sinha.
He is a Manipuri.
Manipuri language,
But-
mother language.
My lord, BSF, my lord. all
Manipuris understand Hindi, don't they?
And before.
Because this section is, just a minute. When any evidence is given in a language which the court of which the court of the accused does not understand, language which the court of the accused, that court or the accused, the evidence shall be translated to the court or accused as the case may be in a language which he or which it or he would understand. The court shall for this purpose either appoint an interpreter.
In the original record.
Just a minute. Or shall itself take the oath of affirmation prescribed for the interpreter. Was any objection raised by him?
No, my lord, not at all. My lord, interpreter, being the commandant as the interpreter, whether you agree, this Sriman Sikaru, my lord, the record we have produced, my lord, alia, my lord, before the single judge, and he pleaded guilty and in all along, my lord, he has replied in Hindi. And the sergeant were also, my lord, he cocked his rifle towards the presiding officer. Third sergeant is, my lord, "Main tumhe jaan se maar dunga," that is his version, my lord.
That is the only ground on which it has been set aside, no?
My lord, that is the main ground, my lord. My lord, as,
Only ground or main ground?
my lord, that is the main ground allowing the writ petition and my lord, that is the ground, my lord, in the appeal also, my lord. So X provided this, my lord, we have.
My lord, in fact, there is not the only ground, my lord. That may be a main ground, my lord. Other grounds is that, my lord. The 4 charges, my lord. The charge number 1.
You are, look here, both of you were, you were part of ambush cum patrolling unit, and you were found to be sleeping. When you were prompted also, you never got up. And when you got up, you became very angry. You cocked the rifle, pointed it towards your superior officer, fired also.
That is not proved, my lord. And subsequent charge, my lord, that is my lord.
And when you fired, nobody was hit. That was just a narrow escape.
My lord, in the subsequent.
There was one cartridge missing, and that perhaps was a missed cartridge that fell in the water body. How could you sleep in that situation when the other side was about to ambush
My
you?
lord, he was not sleeping, my lord. He was.
What were you doing?
He was dozing.
Cocking is all right. You could have taken it in self-defense. Maybe your excessive preparedness. But then you were sleeping. You started using profanities for your senior. You said, "I'll kill him." And who could be a better evidence than this?
My lord,
And
that is
should
not
you be retained in the service?
My lord, that charge is subsequently modified, my lord, to threatening, my lord. Not, my lord,
That's all right.
My lord.
So the first thing was, that's even serious, because that otherwise the first court, summary court would not have done it. It was an attempt to murder. 7. It couldn't have been held. Therefore, it was changed. You never objected to it.
Modified, my lord. Modified threatening, but threatening is not also proved, my lord. If we go through the judgment, my lord, threatening is also not proved, my lord.
We are not inclined to sustain the judgment of your reinstatement. It is dangerous for persons like you to be kept in paramilitary forces. Now, who would trust you?
My lord,
And it more often than not, it is basically not proving the guilt, reliability, suitability. You're not suitable for the job. Unfortunately, we have sympathies for you. That time you may be overdrunk.
My lord,
And there is drunkenness also here.
That was not proved, my lord. That was not proved if I go through the judgment, my lord. And in the threatening also not proved, my lord. The threatening, the charge number 1 is also not
What
proved.
about suitability and reliability as a constable, as a paramilitary personnel? And 134(2) is not, doesn't say that in all cases there should be an interpreter. Manipur is, it is our knowledge, it's a matter of common knowledge which the court can take cognizance under the particular entry in 114G, the illustrations, where court can take judicial notice of this fact that Hindi is understandable, Hindi is understood in Manipur better than any other state.
Very well. Regarding the court proceedings.
And did you raise any objection?
Regarding court proceedings.
Did you raise any objection?
Not, my lord. My lord, 34(2)
of the court martial himself acting as an interpreter?
My lord, 134(2), my lord, prescribes that there should be an.
See, you have to say, it says, when any evidence is given in a language which the court or the accused does not understand. So how would it be presumed that you did not understand Hindi? Where is the objection? The learned single judge has gone only on that.
Since I have decided this, the rest is not included.
No.
My lord, respondent here.
You're not inclined, you're losing your job. Tell me, what else do you want to say?
My lord, regarding the another one, regarding pleading, my lord, he has admitted.
See, on this ground alone, we are not inclined to sustain the judgment. 134 application is.
134(2) is, my lord, there is a clear provision of taking oath, my lord, but the record, there is no reflection of regarding the taking.
Now, 2 follows 1. One is that somebody, either the court or the accused, should not understand. That will be evident only, and that can be proved only if there is a complaint, if there is a demand. If there is a demand. In case there is a demand, the court is left with no option but to engage an interpreter. That's how we read it.
Yes,
If it is presumed, then I was not aware. That's why interpreter is good. That is satisfied the first of it here.
Implementation of 134(2), my lord, provides that the.
You are repeating the same argument and we are repeating the same response. Let us not repeat
The provisional.
ourselves. We are also repeating like you.
My lord,
But what to do?
my humble submission is a procedural error is there.
There is no procedural error.
134(2).
And on fact,
134(2).
this is
my
what
lord.
we are trying to tell you. 134(2) does
Oh.
not get activated. It does not get triggered. आप समझ रहा है कि नहीं समझ रहा? आप मेरी बात समझ रहे हो तो मैं बोलूं, इंटरप्रेटर तो नहीं है हमारे पास. आई डोंट नो एसमीज. हिंदी बोल सकता हूँ, अंग्रेजी बोल सकता हूँ.
I understood, my lord.
So you've understood 134 doesn't get triggered because you never asked for it. Number one, you never made a complaint that you're not understanding Hindi.
Yes.
Correct.
Yes.
So if you had ever done that, and that would have been ignored, perhaps that would have been a great ground, because the person concerned must know, must understand in which language the proceedings are being continued. So you never raised any objection. And then only when you have been dismissed from service, you say that there was no interpreter. And that also, the officer, the court, what is that called? Summary court or something?
Summary Security Force Code.
Compulsory, what is that code?
Summary Security Force Code.
Summary Security Force Court. It, it interpreted, made you understand. Look at the charges. I don't think on that ground alone. You have a copy of the appeal which you had preferred before the appellate authority.
Yes.
Huh? You have the copy, page 53. They come to page 53. This is for our satisfaction that we have made you understand that you have got an order from the court. We are not inclined to sustain it. You will go back to your home. Therefore, we are taking this pain to make you understand that on a slender ground, you should not, you don't go out of the court and say that I did not understand what the court was meaning. Now that you find out and tell us if there is any statement even before the appellate court that you had demanded for an interpreter, that you did not understand Hindi and it was refused.
No.
No. Then for the first time, this wisdom dawned upon you in the High Court. And then the High Court also took a very, very strict view of section 134(2) without first reading 134(1).
Otherwise, my lord, the other charges, my lord, it is as per record, my lord, is not proved by it.
The single judge did not go into all that. Therefore, this order has to go.
My lord, single judge said, elaborately, my lord, I humbly submit that, my lord. Elaborately, my lord, discussed all this, my lord, in the judgment.
Single judge said, since there was no interpreter, it was vitiated, therefore all grounds lost. That's all.
No, regarding other charges, my lord, the also held that, my lord,
29.
Yeah, we don't want to throw them out, but what to do? What is your age? One incident.
In the repetition. At the time of 21, 32 years at 21 now, around
36.
around
आपने वो सब
37.
कर लिया है mental का तो that makes you even less suitable for army service, na?
37, 38, my lord.
Mental condition of your wife, yeah, correct. More मुश्किल है. क्या करें? We can't sustain this judgment.
May I have a, my lord, there, my lord. Let the matter may be fixed after the vacation, my lord. Single chance may be given, my lord.
Huh?
Then let the matter may be fixed after the vacation, my lord, for hearing or my lord. One chance may be given.
That we are inclined because
At least, my lord.
you will lose your job straight away. And it's a long service tenure that you have. Argue differently, we will see, we will consider. We are sympathetic towards you. No difficulty, one incident. There is no case of repeated, drunken behavior. We are conscious of it. There was some family problem you must have, but see, there is no place for a person in a combat team to hallucinate. There's no scope of that.
My lord, on that point.
You were
my lord,
sleeping there with your all arms unprotected.
Correct.
And when the special team crossed through that place, they saw you sleeping with your gun uncocked and thrown somewhere else. You were made to wake up. And then you get angry suddenly that why were you spotted like this? That is solitary incident, Mr. Parashar. Solitary incident, but this is the way. Demand karo. Demand karo.
Okay, again, law is not correct. One is just I'm saying that the law is in use of it.
Anyway, you take time, argue for remand. At least we'll see that.
Obliged.
Argue for a remand, you will get some passage to argue. Go before the learned single judge again. We are inclined to do that. Because that interpretation is incorrect. So make a plea on the next date. Likhe. After some arguments, Mr. A.K. Hannan, learned advocate appearing for the respondent, seeks some time to make further arguments in the matter with respect to the fact that the entire case of, with respect to the fact, now we'll give you some tips to argue.
MJ Karim, sir. MJ Karim.
क्या है वो whoever he is. By the impugned judgment, we have heard Mr. K.K. Parashar, learned CGC for the appellant / Union of India and 3 others, and Mr. M.J. Kadri for respondent number? For the sole respondent. The challenge in this appeal is to the judgment dated 22/7/2025, whereby the dismissal order of the respondent has been set aside by the learned single judge solely on the ground of violation of the provisions contained in section 134(2) of the Border Security Force Rules 1969. Stop. 4 charges were framed against the respondent, but instead of going to the correctness of the summary force court in coming to the conclusion that other charges were proved, the learned single judge found that since the respondent was from Manipur, an interpreter should have been appointed by the force court, by the summary force court, instead of taking it upon himself in his dual capacity to act as interpreter. Section 134 of the Summary Security Force Courts, 134 of the Border Security Force Rules 1969 specifically provides that when any evidence is given in a language which the court or the accused does not understand, that evidence shall be translated to the court or accused, as the case may be, in a language which it (bracket court) or he (bracket accused) does not understand. The section further provides that the court shall, for this purpose, either appoint an interpreter, or shall itself take the oath or affirmation prescribed for the interpreter at a summary security force court. When the documents are produced for the purposes of formal proof, then in that case, it shall be in the discretion of the court to cause as much to be interpreted as appears to be necessary. While assailing the judgment of the learned single judge, Mr. Parashar submitted that there was no complaint or demand from the respondent of appointing an interpreter, and therefore the provisions contained in 134(2) of the BSF Rules 1969 would never get triggered. First up, however, in any view of the matter, the force court, the summaries, हम जहां भी force court बोलते हैं वहां लिखना summary security force court. The summary security force court, by assuming the dual responsibility, itself interpreted it and made it easier to understand, made the proceedings easier to be understood by the respondent. First up, the other submission on behalf of Mr. Parashar is, the other submission by Mr. Parashar is that the respondent hails from the state of Manipur, where Hindi is understood and spoken. First up, spoken. First up. Mr. Reinforcing his argument, Mr. Parashar has pointed out that even in the statutory appeal preferred by the appellant, preferred by the respondent against the dismissal order, there was the ground of the respondent not having understood Hindi, the language which was used in the court proceeding. What did I say? Was never taken. Was never taken. Full stop. On hearing the aforenoted arguments raised on behalf of the appellant, Mr. M.J. Kadri, learned advocate for the respondent, submits that in that case, since the learned single judge did not go to the correctness of the conclusion regarding other charges, it would only be appropriate that the matter be remitted to the learned single judge for a fresh determination. The correctness of the decision of dismissing him. First up, for the purposes of further building up his argument on these lines, first up, Mr. Kadri seeks some time. Mr. Kadri seeks some time. Let this matter be listed for further consideration on. We give you a time in June. Or if you're ready, we will remand.
May, the month of May.
Hmm?
The month of May.
May.
May के बिना अंदर तैयार मेरा.
But with remand also, we will make our views very clear. That on merits, you have nothing to say. Anyway, if you are remanding, we will leave it on a clean slate. Anyway, sometimes in June, sorry.
Along with remand, my on merit, my
We have not decided. Naturally, it is only you argue, formulate your point. This is the only saving. This is the only saving parachute for you.
June 9/6. Item 13.
Surface,
This is lordship, madam. My lord, by order dated 11th, madam, my friend was directed to open instruction on the OTS proposal of the, my lord, petitioner hearing, madam.
Yes.
Lordship, that was rejected on 5/3/2026.
Nothing can be.
And on the day when the
Mr. Das. Mr. Das, nothing can be done.
My lord, that's correct, my lord, but.
We would not have entertained it in the first instance, but
Yes.
since you were very sanguine that you would like to explore the possibility of one-time settlement. The bank should have been interested in one-time settlement
Right.
rather than, but it's the discretion of the bank. They want to recover it, claw it back from you
Yes.
with utmost severity, nothing.
I will, so far that my sale is concerned, I will apply before the DRT by filing appeal. Because that the timeline that they has to maintain for.
We will not pass any
issue-
order, Mr. Das.
But-
We have to be very conscious of this jurisdiction. No order is required to be passed. Satyavati Tandon
Yes,
rings a bell in our minds every time.
Here in this petition, I have challenged the
Right.
order, passed by the, it is a.
You withdraw this writ petition so as to file an appeal before the DRAT.
Yes. So far sale is concerned, one submission, So far that the order passed by the district magistrate, that is cannot be called in question in any other court as per section 14(3), So that order is final, but taking possession. So that order is under challenge here, That order is a challenge.
Can you make this illusory distinction? So would the district magistrate under section 14 have any discretion to do otherwise?
Yes, my lord.
What?
As
Yes.
per the amendment of 2013, that application seeking position of secure
14
asset.
tick points. Sorry, you can challenge it afresh if you so feel like, but here you withdraw this petition. Otherwise, we say that it's useless. They have refused.
Liberty.
After some arguments, that liberty you have.
Yes.
You don't. You came here without our liberty. As after some arguments, Mr. B.K. Das, learned advocate for the petitioner, seeks permission to withdraw this application in order to enable the petitioner to approach the appropriate forum for the redressal of his grievances. Dismissed as withdrawn with the liberty aforesaid.
Item 14 to 17.
Mr. Chaudhary,
Let us wait.
let us wait. Yeah, this is a practical approach. Let us wait. Commission of inquiry is going on.
Well, all the prayers made in the petition has been redressed. Nothing remains in this case. Lordship may kindly see.
Karen, let us wait, Mr. Sharma. You don't understand. Mushkil hai. Have you read the prayers?
Yes, ma'am.
Try and be practical, Mr. Sharma. With respect to the allegation, look at the other prayers that he has made. He would like to wait for the. You want an adjudication now?
No. Trial is going on.
You should have gladly agreed to that proposal. Yeah. Mr. Ken Chaudhary, learned senior advocate for the petitioners, submits that these set of matters be taken up after some time, since a commission of inquiry with respect to fact finding regarding the cause of death of the known singer, known/respected singer Jubin Garg, has still not submitted its report. Let these matters come up for consideration in July.
In July.
In July, he will decide whether to file.
Item 18.
Item number 18, state has filed their affidavit yesterday. So we'll pray for 2 weeks' time to file our reply.
On, off.
On and off.
See, it's very surprising. It was very interesting on the last occasion when we heard this matter. It was very interesting. In the neighboring state of Bihar, when prohibition law was not applied, people clamored for, on license only. Not off license, on license.
In Assam,
Because of the
statute does not recognize anything like rural area or urban area. I do not know.
That is something different. Here you say that
follow.
there the thirst of the claim was more often than not for getting an on license, for the reason that it provided a space and even people did not want to spend much on the ambience and other things. They just wanted intoxication or something. I was surprised that you want conversion from on to off. You have your own reasons. Mr. Goswami will answer that.
Maybe driven by economic reasons also.
But you say that the customers are not ready to pay the extra charges. The corkes, as you say.
Corkes.
Corkes. Can that be a ground to challenge the legislation? No profits because of lack of the will of the customers to pay corkage. Can it be? Anyway, you respond.
I think actually, my lord, what states should ideally do, they should come up with a comprehensive law, my lord. From time to time, amendments are being made. That is why, my lord, lot of loopholes are there. Because I was connected with enactment of the earlier amendment, my lord, as a law officer. So even we suggested that we should go for.
But these petitioners are all bar owners. These are not shops.
On shop.
No, on shop, all right, but Captain Cook Bar and Restaurant,
There's a slight difference between.
Kohelika Bar and Restaurant, Amazon Restaurant. And where is the difficulty here?
Now, these are not like.
These restaurants. Anyway, Mr. Ken Chaudhary, and senior advocate, seeks some time to file a rejoinder to the reply affidavit filed on behalf of the state. Stop. Let that be done by the next date. Re-notify July?
Yes.
Sometimes in July.
28 July 20.
Yeah.
Item 20.
You have a next date.
We have filed the affidavit
Yes.
because that earlier order appointing the inquiry officer was not brought on record.
Yes.
If your lordship would kindly come to page 262, my lord. Page number 262. Whereas in compliance of the direction of the Honorable High Court Gauhati, passed by the order dated 24/11/2023 in WPC number so and so, titled as Om Prakash Agarwal versus State of Assam, de novo inquiry is being held against Om Prakash Agarwal, financial controller under suspension, under Rule 25 of the AIDC Employees Conduct Discipline Rules so and so. Whereas the underside considers that in absence of any specific order of the Honorable High Court, with respect to quashing or setting aside the previous show cause notice dated 19.
No, let's see the High Court order.
Yes. High Court order, my lord, it starts at page number 144. Lordships may kindly come to para 160, internal page 17 of the judgment, para 16. Under such circumstances, this court is of the considered view that the reliance placed by the inquiry officer upon the preliminary inquiry report conducted earlier by the department is completely contrary to the law postulated by the apex court, and therefore it cannot be accepted to be a correct procedure. This court, upon giving its anxious consideration to the issues involved, as well as having regard to the law laid down by the apex court is of the considered view that inquiry report dated 30/10/21 submitted by the inquiry officer pursuant to the disciplinary proceeding inquiry initiated against the petitioner by department is required to be interfered with and set aside. The matter is accordingly remanded back to the department to proceed with the de novo.
So there could be two interpretations of it.
Yes.
The context in which this order was passed and paragraph 16 thereof would amount to mean that would tantamount to a completely a de novo in real sense of the term inquiry,
Yes.
where everything else vanishes
Yes.
except your suspension, which shall be continued and you shall be given the subsistence allowance. And thereafter a fresh inquiry where everything had to be afresh. So therefore, this must have meant to the authorities of a fresh inquiry with a new inquiry officer. Just a minute. You faced the inquiry with a new inquiry officer. Did you or did you not? Did you question?
No, my lord, there is no question. My lord, I have no option. Even if I come to High Court.
No.
No, my lord.
With the designation of a new IO,
Yes.
did you question that? We are asking you.
One second. I'm sorry, Milord. No, inquiry officer. No, Milord, I have an answer to that.
But first you understand my question.
Yes, the question is, Milord, whether we have raised
We
any
will,
objection.
Mr. Chaudhary, we will hear you on the concept of new IO.
Yes.
We will look at K.R. Dev. We will also look at other judgments by Justice Gogoi and other latest judgments also. Agreed. We know about the proposition. But here the question is different. Here
I'm trying to
so
make
you
a
have understood.
submission on the purport of this paragraph.
You have understood what
Yes,
we are
I've
asking.
understood.
Because
Now,
the
Milord,
purport
what
is
the first
complete. Efface everything what has been
Now,
done.
Milord, that is where we'll have to understand what in legal parlance is meant by de novo inquiry.
No. Before
No,
that.
yes. First step would be
Question
what
is-
was ordered was a de novo inquiry.
No, Mr. Chaudhary, that is the second question. The first question is whether this could have been done. This was subject to challenge because you should have challenged this remand only. Whether, even if it was helpful to you. For the reason that if the court found that it was completely bad, it cannot give another opportunity to the state to put up this case.
No, Milord. No, Milord. The concept is further inquiry can always be ordered. If the disciplinary authority
That's
finds.
right. They say that further inquiry was not possible in this circumstance
Here
because
was
it was based on a report.
Here was a case where a preliminary inquiry report was taken note of. Supreme Court says in that preliminary inquiry, if you are not associated with, then such an inquiry report cannot be a part of the inquiry report. Eventually, the earlier order of punishment was, Milord, premised on also on the preliminary inquiry.
Anyway, so
that is why court interfered.
So with this de novo inquiry,
Yes.
were you aggrieved at that time that it was a de novo inquiry?
No, Milord, what our expectation was that the same inquiry officer will do the inquiry.
No. So immediately after the inquiry officer was appointed, you
Yes.
should have come to the court and said that no, this was not the direction. It cannot be done according to K.R. Dev.
But sometimes, Milord, a procedural flaw creeps in a decision-making process. Does it mean, Milord, that every time we have to go immediately?
No, it doesn't
We can
mean-
take note of that
it
at the
doesn't
final
mean-
hearing also.
No.
When the proceeding terminates into an order, we can take all these grounds.
But you agreed for it, no?
So, Milord,
Anyway, but you argue what is de novo.
My understanding of de novo inquiry is it has to start from that stage. What is the state? No, kindly see the first para of the impugn order. That makes the position very clear.
Yes, Mr. Chaudhary.
Yes.
I have recently gone through those judgments, but my understanding is that when there is a remand, it is always from the stage of the vulnerability.
Yes,
where the vulnerability surfaced, where it was pointed out from that stage.
Vulnerability
And
is
the
taking
courts-
note of the inquiry report.
And the courts remanding the matter, the superior courts remanding the matter to the executive authorities, to the quasi judicial authorities, they specify that from this stage. Now here the court directed for a de novo inquiry. That means you don't remember of anything. It's a fresh inquiry.
Even if it is a fresh inquiry, Milord, when the
Shows
earlier
the
inquiry
judgment-
officer is
shows
there.
the judgment from ECI versus Karnakar and K.R. Dev. Shows.
Yes.
Or any other judgment that you wish to
Yes.
cite before us.
Milord, first judgment is, Milord, K.R. Dev.
It's 1970s.
Milord, it starts at page 1. Please come to, Milord, page number 4. Para 12. It seems to us that Rule 15 on the face of it really provides for one inquiry, but it may be possible if in a particular case there has been no proper inquiry because some serious defect has crept into inquiry or some important witnesses were not available at the time of the inquiry or were not examined for some other reason, the disciplinary authority may ask the inquiry officer to record further evidence. But there is no provision in Rule 15 for completely setting aside the previous inquiry on the ground that the report of the inquiry officer or officer does not appeal to the disciplinary authority, the disciplinary authority has power to reconsider evidence itself and come to its own conclusion under Rule 9.
No, that's right. That was in a context where the
No, my lord.
opinion of the inquiry officer was different.
In a given case, rather here in this case, my lord, maybe the inquiry report did not appeal to the disciplinary authority, therefore it was changed. But my lord, the underlying principle which is discernible from this paragraph is also a fact that Rule 15 of the CCS rule envisages only one inquiry. And in case of any discrepancy, in case of any wrongdoing or anything, my lord, it envisages a further inquiry. It does not envisage another inquiry by another inquiry officer. That is my humble submission, my lord. Then, my lord, will kindly come to the next judgment. At page number, it starts at 6. Union of India versus K.D. Pandey.
Yes.
Now here the Honorable Supreme Court has gone a step further, my lord. Please come to paragraph 3, 4 and 5 at page 7. The proceedings were initiated against respondent number 1 in respect of 6 charges. The inquiry authority in the report made held that none of the charges stood proof. Thereafter, the Railway Board, in exercise of the power under Rule 25 of the Railway Servant Discipline Appeal Rule, examined the matter and found that 4 of the 6 charges could be substantially proved beyond doubt with the available documentary evidence, and thereafter remitted the matter for further inquiry as contemplated under Rule 25(1)(c) of the rule. On remit, the inquiry officer made a report finding respondent number 1 guilty of 4 charges. Based on that report, Railway Board dismissed the respondent number 1, which was challenged in the dispute raised by him. The tribunal as well as the High Court are of the view that on the same material, a fresh opinion has been furnished and it was not a case of further inquiry. Indeed, it was not noticed by the disciplinary authority that inquiry held earlier was bad or that the management or the establishment did not have the proper opportunity to lead evidence or findings were perverse. In the absence of the same, it was held that there was no justification on the part of the disciplinary authority to commence a fresh inquiry on the same set of charges. Learned counsel for the appellant contended that in this case, the board had examined the material on record and come to the conclusion that 4 of the 6 charges could not be proved on the available material, which had not been properly examined in an earlier inquiry. In fact, from the order made by the Railway Board, as well as from that part of the file where the inquiry report made earlier is discussed, it is clear that specific findings have been given in respect of each of the charges after discussing the matter. If that is so, we fail to understand as to how there could have been a remit to the inquiry authority for further inquiry. In this resulted in a second inquiry and not a further inquiry. Now, my lord, what I'd like to emphasize relying upon this judgment is the principle of law is, my lord, there cannot be a second inquiry.
Second inquiry वो उसको कराए कि इस
What is permissible is a further inquiry.
तरह के नहीं करना, otherwise it will go on perpetually. ठीक है, but we don't accept this.
So, my lord,
Yes.
my submission based on this judgment is this is also an authority for the proposition.
Now what happened after this? After this, another inquiry officer and you are dismissed again.
Yes.
You challenged that,
Yes.
but you did not challenge the
No,
constitution.
my lord, that's what I'm saying, my lord. I think, my lord, that right subsists, my lord. There cannot be a waiver of fundamental right, my lord. Even if I waive.
Now what happens? Then there will be a third inquiry. If we do it, it will be a third inquiry. Believe from that stage the same inquiry
What we
officer.
can, from that stage,
Mr.
from the stage of vulnerability
Chaudhary,
to.
Mr.
put it
Chaudhary,
into
what we are
concept
saying
of
is this, you are understanding what you are saying.
Yes.
Now, in the first inquiry report, disciplinary proceeding was concluded, holding you to be guilty. You came before the court found that since the preliminary inquiry report was not given to you, you were not, you had not
Associated.
participated, therefore it could not have been based fresh inquiry. Now a this was a second inquiry concluded, you never questioned that new IO should not have been there. Now if we set it aside, K.D. Pandey, the apprehension of the Supreme Court in, just a minute, the apprehension of the Supreme Court in K.D. Pandey, I'm telling something different. you keep aside your, argument line. Now, the apprehension of the Supreme Court in KD Pandey was that if this is permitted, it will amount to, a
A second
perpetual inquiry, a second inquiry and a third inquiry, whenever the report would not be acceptable or whatever. So this, you are making it happen because you did not question the appointment of a fresh IO. You could have said that this de novo means this, or you could have questioned this before a division bench. You don't question it, de novo inquiry, and then the inquiry commences. You are again dismissed.
But the de novo inquiry has a definite legal connotation. As
Am
the
I
Lordship very rightly
am
said,
am
the
I
idea is.
am I disputing that?
No,
De novo is, we are understanding this.
Yes.
De novo is a different concept.
yes.
De novo, then a decision had to be taken whether inquiry at all.
Well, for a moment, it is
The
not.
question is this. Now, with your capitulating to the order of remand, which in the beginning you thought it to be good, because your sentence, your punishment was being done away with. You wanted to see what befalls you in future. You allowed yourself to be subjected to a proceeding. Now, after you have been dismissed again, you question this very remand. That is our ground. It subsists. Any injustice subsists. But in this circumstance, why should we interfere?
Lord, as held in on Nelson notice and all these cases, when there is a flaw noticed in the disciplinary proceeding, the natural consequence is you would be deemed to be under suspension, and the proceedings has to continue.
Now look at this. Are you a clerk in the office?
No.
You are the head man.
Financial controller.
Your financial company, you shifted the funds from central bank to some other bank to central bank, and in the process it was found that you gave it to a fake company.
No,
And
it's
several crores were.
Not a single farthing was lost by the AIDC.
That is different.
Yes.
But could you be trusted? Could you be retained in service? That's the question. That's a different thing. So therefore, where are you? Therefore, we went on facts. The question is that you understood it, no? And you allowed yourself to be subjected to the proceedings. Now you're questioning the end decision by taking us back to the original remand order. Have you not exhausted that chance?
No. If the inquiry is not held in accordance with law, then there is no difficulty in directing a fresh inquiry from that stage.
The moment you question Justice Saikia's judgment of de novo inquiry.
No, I'm not questioning. We're happy with the order, my lord, because our understanding is now the inquiry officer will start the proceeding. No, that's why I'm saying, my lord.
Inquiry officer, midway also you could have come, no?
No, my lord, that disciplinary authority understood the order properly. Please come to 262 for a moment.
I will definitely go to all arguments. It's an interesting argument, but
Yes.
You have to satisfy us first.
Yes.
Pursuant to this order, new IO was appointed.
My submission would be there cannot be waiver of any fundamental right.
And this is this is not a waiver of fundamental right. You subject yourself to the proceedings.
No, my lord, even if I have waived, my lord, the authority is bound to follow the rules. Even if I have waived.
Then we will have a third inquiry. It will never end. We'll say that.
Inquiry, Lordship will specify from what stage the inquiry.
No, but in
The
any
same
case,
inquiry officer.
for all practical purposes, it would be a third inquiry now.
No, my lord.
For all practical purposes, whether X is the inquiry officer or Y is the inquiry. Now, which inquiry officer do we want? The first one. It is not possible now.
He's there in service.
He may be, but with this cubic feet of water having crossed through the bridge.
End of the day, that procedural safeguard I must get. That's the only thing I enjoy.
You enjoy, but we are ready to hold this. That because you subjected yourself to this, now there is a second inquiry, and you're challenging this. This ought not to be deemed as waiver of your fundamental right. Fundamental right, you have a right to defend yourself. You have a right to be subjected to a correct proceeding.
Exactly.
But you don't have
to be subjected to a right procedure.
You don't have a fundamental right of being subjected to a proceeding headed by Mr. X.
It's not my choice. That's the law of the land.
So
it says,
did you not capitulate? I'm not going. I am not able to go beyond that line. That is my difficulty. We understand K.R. Dev, we understand KD Pandey, we understand ECI Karnakar. We understand Vijay Kumar Dubey and my judgment in Patna High Court, where I have set aside the judgment of a single judge saying that de novo inquiry. We said, no, no, don't do this. You recognize the flashpoint, the point where the vulnerability surfaced. From that point, you may remand. We have done that. I have passed judgments. But here, situation is different. There is no question of not understanding the proposition of law that you are advancing. We understand.
Definitely not.
Here,
all
there
that-
also we are ready
all
to
that
distinguish.
I'm trying to pursue your lordship is merely because I have submitted to the inquiry proceedings, my lord. Would that disentitle me to
From
point to
questioning
a
this,
procedural flaw in the process?
now in this context only, let me repeat my anxiety, our anxiety, that in that case, allowing it on whichever ground, there will be a third inquiry, which would completely vitiate the purpose, number one. And number two, you are not the person who could be given this latitude of not understanding what is happening to you. You had the financial corporate, branch dealing in crores and crores and billions.
Well, Lord, my only humble submission is lordship will kindly deal with that argument. That merely because I did not objected to the appointment of Mr. X as the second inquiry officer, that will not take away my right. Because if there is any procedural flaw, that lordship will have to answer it.
Sorry for repeating. This would be a tautological kind of a response. But then this amounts to, accepting your plea amounts to a third inquiry.
Of course, no logical
It continues. Then the apprehension of Supreme Court in KD Pandey.
The third inquiry, I'll put it a further inquiry. I'll never put it third or fourth. It will be a further inquiry.
This is what he had no occasion to do that. Listen to what my brother says.
Yes, ma'am.
We have never raised after even remand. When inquiry officer in your reply, after final reply to the inquiry report, nowhere have you.
You had every occasion to forestall it.
Times,
Something that this is prejudicial to me, because in a departmental proceeding, what prejudice has been caused to you, you must highlight in your reply even in the inquiry officer.
No, Lord, I need not plead prejudice in a case.
Mr. Chaudhary, Mr. Chaudhary waited to see which side the camel, sleeps.
That is not it. To respond to Honorable Justice Chaudhary, my lord.
Same question.
My submission is very simple, my lord. Assuming I would have raised the objection, what difference would have made, my lord, today? Because I did not plead prejudice for violation of a
You could have straight away challenged it. The other side would have objected, saying that this is court annexed. This is on the directions of the court. Then you would have gone for review. And you would have said that very well, remand is acceptable, but de novo, they are wrongly understanding. They are employing another person. They are engaging another person as this. The learned single judge would have reviewed the order and would have said that de novo means a fresh inquiry from that stage with the same IO. And where is the prejudice to you now?
Procedural right flowing from Article 14. I'm sorry, Millard. I don't have to plead prejudice. With all respect.
No, not necessarily.
Article 14. You can't pitch an Article 14 here. You can't pitch an Article 14 here.
I've been denied equal opportunity.
No.
This is the law of the land.
You are not very serious. I'm sure you're not very serious about this. I'm sure you're not very serious about this contention. I'm sure. Who is denying you the opportunity? We say that you knew about your opportunities. You very conveniently tried to evade that. You subjected yourself to the inquiry. Now, I don't think all these legalistic argument with respect to something which had happened, which has been consumed. I mean, the directions have been consumed, the directions have been followed. Now you are aggrieved. Question it on that ground, whether on acceptance of everything. With a new inquiry report also, you should not have been subjected to a punishment of dismissal on the ground that it was a mistake you could not discern, and that this assessed the concept of proportionality. This is the only passage that you have, to my understanding.
In that
Otherwise-
case, my lord, lordship will give me a
Or if you-
liberty.
We will.
At that, to be precise, my lord, to be honest, I didn't came prepared with that argument.
Actually,
That I'll do
this was your ace point, but we are not ready to accept it for reasons which we have told you.
Okay. On the disproportionate punishment part, my lord, lordship will give me one date, I'll do that.
And disproportionate in this, you are a very, very senior officer. In that context,
Certainly. I'll
suppose
try.
the money would have been siphoned off.
The proportionality as a part of the decision making.
Ranjit Thakur and Ranjit Kumar,
Ranjit Kumar Thakur.
Ranjit Thakur and that Gayum
Justice Venkat Chalaya.
and no, Justice T.S. Thakur and
No,
just
Ranjit Kumar Thakur.
T.S. Thakur.
Ah.
T.S. Thakur. And yes,
Venkat
and
Chalaya.
Gayum's case, it's
I think the first on this point is illustrated judgment is my lord Ranjit Kumar Thakur, that army case.
first time this proportionality concept came in service jurisprudence, which is beyond, I mean, comprehension, but it is not followed seriously unless it shocks the human conscience or that rider is too big to be overcome. We can do it for small people of lesser vintage, not for corporate honkos. Anyway, we will. These are all observations.
Yes.
Yeah. Do we deal with this point now?
Together.
As a litigant, we'll say.
Yes.
We'll say something has to be said. No, so
Yes.
much of argument. Mr. Kencho, who appears for the other side?
I'm appearing, my lord, for the respondent corporation,
For the respondent, you are Mr.
Nishan Das,
Okay. We have
for
heard
respondent number 2 and 3.
We have heard Mr. Ken Chaudhary, learned senior advocate for the appellant, and Mr. Nishan Das, learned advocate for respondents number 2 and 3. The appellant served as financial controller, Sam Industrial Development Corporation Limited, government corporation under the Companies Act 1956. Year 2020, the fixed deposit of the corporation parked at Canara Bank had matured. The appellant, with a view to augment the profit by interest, profit through interest, explored the interest rates quoted by interest rates provided which could be provided by other banks, so that the amount, the fixed deposit amount could be invested with a bank which gave the maximum benefits to the corporation. The entire process, it is the case of the appellant, was transparent. This process attracted quotes from 10 banks, quotations from 10 banks. But the choice fell on Central Bank of India. At that time had offered the highest rate of 5.6% per annum. A decision thereafter was taken to transfer the fixed deposit amount at Canara Bank to Central Bank of India. Stop. Fixed deposit certificates also were issued by the Central Bank of India. Stop. It was only later that it was learned by the corporation that the money had been transferred to a fake of Messrs. Rehana Enterprises, which had already been freezed, which had been frozen. What is the expression? Freeze or frozen? Which had been freezed on August 6, 2020. Stop. The Central Bank of India filed a case for forgery. First up, simultaneously, the corporation had also filed a case by FIR number 301 of 2020. The appellant in his capacity as financial controller, who was at the helm of the affairs with respect to the aforenoted decision, was arrested and was released on default bail. So far for the facts of the case. The corporation initiated a disciplinary proceeding against the appellant. So the inquiry report revealed that the charges against him stood proved, whereafter he was visited with the punishment of dismissal. The appellant challenged the aforenoted punishment before this court by WPC number 5085 of 2022. A bench of this court by judgment dated, bench of this court in the aforenoted writ petition by judgment dated 24/11/2023 on finding that since a preliminary inquiry report conducted by the department in which there was no participation of the appellant was relied upon by the inquiry officer, the entire inquiry against him stood vitiated. The punishment, therefore, was the order passed by the disciplinary authority was therefore set aside, and the matter was remanded to the department to proceed against the appellant within quotes with italicized, with a de novo inquiry against him. The learned single judge further clarified that the department shall not rely on the preliminary inquiry report dated 7/11/2020, which was earlier conducted by the department. Stop. The appellant was directed to be treated to be under suspension, who shall be granted subsistence allowance as per the provision of law. First up, after the completion of the de novo inquiry, the disciplinary authority the learned single judge directed, will arrive at its own conclusion on the basis of the inquiry report as may be submitted, and thereafter consequential orders would be passed by the department as per the provision of law. In compliance with the directions in the aforenoted judgment, a de novo inquiry was started with the appointment of a new inquiry officer. The appellant submitted himself to the inquiry, where he was again visited with the punishment of dismissal. This dismissal order was challenged by, this time the dismissal order was challenged by the appellant before this court by WPC number 6791 of 2024. The correctness of a de novo proceeding with a new inquiry officer having been appointed in the proceedings. It was contended on behalf of the appellant that a second inquiry under the rules is not permitted. If at all the learned single judge in the first instance found that departmental inquiry report in which the appellant had not participated was relied upon, the entire proceeding was set aside and the matter was remitted to the department for a de novo inquiry. This de novo inquiry, therefore, Mr. Chaudhary on behalf of the appellant contended, only meant the start of a fresh inquiry from the stage of the vulnerability which had surfaced before the learned single judge. Namely, the reliance on a report of the department which was almost ex parte. The learned single judge in this instance did not accept the contentions of the appellant and upheld the punishment imposed upon the appellant. The appellant seeks to question the very interpretation of the direction of the court in the first instance in WPC number so and so regarding a de novo inquiry. Did it mean appointing a new inquiry officer? And if so, whether that would amount to a second inquiry. Since this was the main question urged by the appellant, the tentative view of this court was, during the course of hearing, that once the appellant had subjected himself to such inquiry in which a new inquiry officer had been appointed, he could not then question after the conclusion of the departmental proceeding against him the appointment of a new inquiry officer, which according to the appellant meant a second inquiry. Again, first up, Chaudhary, learned senior advocate, therefore submits that he shall address this court on the next occasion on other issues, especially with respect to the quantum of the punishment, the proportionality of it, especially in view of the fact that there was no loss to the bank and the entire money was recovered. First up, let this matter come up for further consideration. I think on that day we will remember this. Come up for consideration. We are not referring to your arguments, Mr. Das, for the reason that
Please,
this was a tentative view. On that day, you come prepared on that.
Please, my lord.
Yeah, score another than I file.
Can I make an unusual request? Item number 26 couldn't be taken up at 2 o'clock.
Item number 26, why not?
Yes.
What is that item?
That matter, my lord.
Oh, Sajal Das, principal. Hey, 2 o'clock.
2 o'clock.
Yes.
Deep.
So we'll get up for a while.
23rd June.
We'll come back in 5 minutes.
Process been completed, lord.
I don't think you have a case here to pursue. It's all over. Rightly or wrongly, it's all over.
That is true.
Look here, with the publication of the voter list and the state to go to elections on 9th of April, this petition has become infectious, dismissed as having become infectious.
Right.
Item 24.
Yes, who appears for the state irrigation department?
And for respondent number 1, 5, and 6.
We are concerned with the appellant. Only when the appellant presses his case, then we look at you, no? Nobody appears on behalf. Yes, state. Mister? Where is he? He was here, no?
The copy of the detail will may be provided to us, my lord.
Give a copy of the appeal. Give a copy of the appeal, we only adjourn it. We don't say in the absence of Mr. Naik. Yeah. Like here, the learned counsel appearing for respondent number 1 and 2.
1, 5, and 6.
1, 5, and 6. Let a copy of the brief be handed over to Mr.
S.H. Mahmood.
S.H.
Mahmood.
Mahmood, learned counsel for respondent number 1, 5, and 6 during the course of the day. Let this matter come up for consideration in June. June.
15 June.
Respond if you so like.
Item 25.
Yes. Louder, sir, louder. We can't hear you.
Appearing on behalf of PGN on your lordship. As per the last order, that like to file affidavit, your lordship.
May I plead, your lordship? The last affidavit was filed on 10th of March, your lordship. Thereafter.
Have you served him a copy?
Yes, that was filed thereafter the.
All right, they have filed. You argue?
No, your lordship.
Thereafter, your lordship.
Thereafter the matter was listed again, your lordship.
Last order, 12,
12,
2026.
12, the matter was listed.
Shall provide
again.
necessary documents to the learned advocate general. Is this matter again? भेजेंगे उसके यहाँ?
Lordship. Lordship, a
File it,
subsequent affidavit was ordered, your Lordship. For that, your Lordship, they,
file your affidavit, bring it on record, we'll see it. The Advocate General is appearing in, no? Let him be able, it's not a problem. Take it. अपने लग ग्रहण पर टाइम नहीं ले सकता था लिखिए the affidavit as required by order dated 12/3/2026 has not yet been filed. Let the same be filed by the next date, re-notify July.
22nd July.
Obliged. Okay. Okay. You people are very, you speak very softly. I can't hear. The microphone is not functional and they don't use their lung power.
Yes.
It's on. You have to be a bit louder for the microphone to catch your voice. Suppose I say, what did you say? Would you understand? Then at times it causes irritation. Every time, you see, I go back to my chambers with a feeling that I have become hard of hearing. I always have to ask, huh? Speak a bit louder. Yes. Still, I did not hear you. Anyway, so.
I love you, huh? Item 27.
One second.
But 29 was.
Yes. What is their instruction now?
As per my instruction, Lordship, she has already been promoted to the post of senior assistant.
What is it?
She has already been promoted to the post of senior assistant, Lordship.
So you don't press this now. It's
Okay.
over. She has already been done, no?
Yes, Lordship.
So there is no need to press all this.
Yeah, yes, Lordship.
My submission is that, my lord.
We were absolutely not comfortable with the order of the tribunal. That was wrong.
My lord,
But nonetheless, you have won it,
my
so
lord,
therefore they are not pursuing the matter.
may I submit
Lordship.
for 2 minutes?
Why?
For 2 minutes, may I
Why?
submit?
Why?
I have been promoted through the, I was not promoted for limited departmental competitive exemption, which I have qualified.
Which you qualified. Be happy with that.
I have been promoted by virtue of the seniority, accelerated promotion as an second.
Therefore, the matter has to be decided.
yes,
We will set aside the order of the cat and we'll say that now, since you have been already
My lord,
promoted, not under this channel, not under the merit channel, but otherwise.
Sorry, my lord, I'll take 1 minute.
I will hear you.
Sorry, 1 minute. I'll take 1 minute. My another submission is that my initial appointment was in terms of the rule. Because at that time, when the staff selection could not sponsor the candidate for filling up the post of LDC,
Then, my lord, the chairman relaxed the power, and relaxation power clause is in terms of the rule itself, rule 8(7). Relaxed the clause, and thereafter, my lord, the on 2 occasions they did not
Tell me one thing.
did not join.
The appointment made in the year 2013, in the
11.
year 2011.
Ad hoc. Through a selection process.
Just a minute.
My-
2011. Did it not stipulate that it is only ad hoc, temporary, it shall not be counted towards regular service? Did you challenge that?
No, my
You
lord.
never.
On
In 2013, you were regularized.
regular.
You did not ask for yourself to be regularized from 2011. And then this wisdom dawns upon you only in the year 2021 when the limited departmental examination is introduced.
I was short for duration of the length of
Correct,
service.
correct. So
Yes.
therefore, only because it was not to your advantage, you did that. Otherwise, you are happy with 2013 regulation.
My lord,
Even otherwise, we shall not do it for the reason that there is a specific rule which says, there is a circular of 2015 perhaps of the central government which says that for these purposes, the reckonable date is from the date of the regularization.
my lord,
Correct.
that they have included, I will interpret in other ways.
Anyway, we are not interfering. We are
My lord,
interfering with
I
the
am
order.
relying-
You want this?
My lord,
yes.
I am relying on the law, on the 2015.
Anyway, we shall not deal with it.
1511 is.
Ah.
Then the director engineer
Hey,
dealt,
bada mushkil hai.
so and dealt,
Already been
and
promoted
if
by.
my initial appointment is in terms of the rule,
What difference is it going to make so far as your career
then
is
my ad
concerned?
hoc period is liable to be counted.
Hmm?
If my initial appointment is in terms of the
You are
rule,
you are very ambitious. Do it.
my lord, then my lord, my submission may be recorded this much.
Definitely give your submission. We don't dismiss the petition without recording our reasons, Mr. Nath. You should have known by this time.
Yes, ma'am.
And while recording, we will also say that this is what this is.
My,
what you've done.
my humble submission this day, my initial ad hoc appointment is in terms of the rule. And uninterrupted ad hoc service regularized without further selection.
No.
Initial selection,
After 2015, there are about 10, 20 of the Supreme Court decisions which say no.
My lord, there has been dealt in para 15, relying on this factual situation of the case. My factual situation of the case, here I am relying, because the factual situation is akin to this case.
नहीं उसको तो फिर seniority दूसरा हो गया ना, because limited competition that would have been earlier.
Because my initial appointment was.
And what happened to that examination in which this court permitted, the tribunal permitted him to appear?
Lordship, it was, his, one post was withheld, Lordship.
One post was?
Withheld, Lordship, result was withheld, Lordship, because.
One post was left vacant and the other posts you filled up. That filling up exercise was done when?
Lordship, in 2024, the result was declared, Lordship.
So therefore he will have some ground to argue, which we are not entertaining his arguments, but he will have some ground to argue, because if he gets through this channel, he would be senior. Correct.
I am coming to the page.
Just a minute.
Yes.
Yes.
Para 8, 9 is related, similar to my submission. That is submission. Then my lord, para 14, relying on all the judgment directed to class 2 engineers, Rudra Kumar Sen, 2020, 2000. And my lord, page 14, it has come to the principle of the law. Rule, para 14, page 18.
Paragraph 8 and 9.
8 and 9, similar to my submission, that para 9, 10 also, my lord, 10, my lord, I am reading the submission of the learned counsel. For the writ petition submitted, the view taken by the larger bench in the High Court is based on erroneous assumption that the appointments of the writ petition are stopgap arrangement and rehearse the rules. Careful perusal of the scheme of the rules and their working knows that the appointment of the writ petition was neither against the rules nor was any stopgap arrangement. It was made clear by the learned counsel for the writ petitioner that the claim of the petitioner was limited for counting services from 12/6.
Where do we get your appointment letter in 2011?
Which one, my lord?
Your appointment letter in 2011.
A appointment letter.
Page 69, Lordship.
2004, 1,
Page?
2011, page
Page-
70.
Page 69 of my petition, Lordship.
Page 69 is the of order. Has been
Annexure
posted
H.
as LDC on ad hoc basis for a period or till further orders until effective there. When she is assumed the LDC in the central administrative grade PM so and so, ad hoc appointment will not bestow any her right of regular appointment to post procedural service and may be
Will
terminated.
not bestow any right for regular appointment to the post.
Yes.
Yes.
Thereafter,
And thereafter you are continuing.
continuing, and no regular selection was conducted in that
Correct.
selection.
But does it depart from the proposition that you were never, this was not to be treated as a step towards the regular appointment?
My lord,
And that is what has been decided in Agornath Day.
yes, Agurnath Day. But Agurnath Day said if there is rule is, you are not in terms of the rule. I am here appointed in terms of the rule because relaxation clause is.
Maybe, but this.
And choice selection because 40 candidates sponsored by the staff selection and
Right, we have taken your.
I was at the top of the list. Then my lord, I am that this is my submission and my lord the uninterrupted service. My submission is that in terms of the rule because relaxation clause is their rule and without any further selection. Rule the power to relaxation, so relaxation done. Service was usually ad hoc, uninterrupted, continued, and the same selection, which is qualified by the staff selection commission. That is in there. If that is my, if my initial appointment is bad, my lord, then even today my appointment is bad.
Come to page 71.
71.
She was not selected by staff selection commission, Lordship. It was
Yeah, that is
employment. Expert.
Sponsored by the relaxation,
Come to page 71.
page 71. SSC letter could not recommend for appointment. I hereby inform that neither the candidates did report for duty consideration considerable period of time. Yes. None
In the
there.
absence of that, you were again given a stopgap arrangement. Then 72.
Yes. That has been taken care of by the tribunal in the entire facts has been reiterated.
Specifically made it known to you.
Tribunal has.
It is made clear that the ad hoc appointment can be curtailed at the discretion of the competent authority even before the prescribed period, and the appointment will not bestow upon her any claim for regularization in the post, and the period of ad hoc appointment will not be counted for the purpose of seniority.
Yes,
And
all this happened. But by virtue of the law, my lord, I am protected because my initial appointment is in terms of the rule and I continue to that any
we will record your submissions.
And,
Be happy with it. We are dismissing this. We are allowing the writ petition on behalf of Union of India. We are setting aside the direction of the tribunal, and we will also be recording a fact that now that you have been promoted.
Yes.
for seniority, for the mode of seniority in terms
Nothing. We are not going to give you anything. Take down. We have heard Mrs. R. Devi, Learned Central Government Counsel for the Union of India and three others, and Mr. S. Nath, Learned Advocate for the sole respondent. The respondent worked as lower division clerk in the Central Administrative Tribunal, Gauhati bench, as a temporary employee, which according to the petitioners was a stopgap arrangement to fill up urgent vacancies while waiting for the permanent hires through the Staff Selection Commission. The ad hoc tenure of the respondent was extended and ultimately her services were regularized with effect from 13th of August 2013 and not from her initial joining date. This meant that her earlier tenure as ad hoc employee from January 2011 to August 2013 was not to be counted towards her seniority, promotion, and other benefits. In the original appointment order of the respondent and its continuation on several occasions, it was made very clear that such appointments or renewal will not bestow on her any right for regular appointment to the post or for continuation of service and could be terminated at any time without assigning any reason. Full stop. What did I say इसके पहले? The paragraph which, last paragraph, the ad hoc tenure of the respondent was extended. Did I say that? कहाँ से लिखाना शुरू किया है मिस्टर खान?
Subsequently extended on with clear terms.
आप पूरा जोर से पढ़िए. लास्ट पैराग्राफ 3, 4, 5, 6, 7 लाइन आप पूरा ठीक से पढ़िए. मिस करिए, लिंक छोड़िए.
The initial ad hoc appointment was subsequently released.
छोड़िए सब. ये कहाँ से?
ये लाइन पे immediate
उसके पहले उस जस्ट बिफोर दैट कहाँ लिखा है?
appointed वहां से शुरू.
My stenographer has had this problem. कभी इन लोगों को बोलते परमिशन. हाँ? Not from her initial joining date. This meant. नहीं, this meant that her earlier tenure. Promotion कहाँ लिखा है? From January 2011 to August 2013 was not to be counted towards her seniority, promotion and other benefits. उसके बाद क्या पढ़ा? उसके बाद क्या लिखा? ऑल यहाँ पर लिखा है, वहां से बंद करो. ठीक ठीक. 2021, the Staff Selection Commission announced a limited departmental competitive examination for promotion of upper division clerks, for promotion to the post of upper division clerks, with the requirement of having served as regular lower division clerk for 5 years, to be counted from 1st of July 2017. For the regular appointment of the respondent having been made in the year 2013, she did not have the requisite eligibility experience for her to apply for limited competitive examination. It was only at that stage that the respondent approached the tribunal for counting of her services during her ad hoc period also, on the ground that even though the appointment was ad hoc and temporary, ad hoc / temporary, it was against the rules. It was in consonance of the rules, which was very evident from the pay scale which was allotted to her. Based on the aforenoted submission, the tribunal by its order dated 17/5/2024, in fact, set aside the rejection order of such, the rejection letter set aside the letter rejecting the request, letter of the department rejecting the, letter of the tribunal rejecting the request of the respondent in not counting the ad hoc service period for adding to the requisite experience of the respondent to appear in the limited competitive examination. First up, the tribunal also directed for granting of all consequential benefits like seniority and financial upgrades to the respondent, treating her service to be regular from 4/10/2011 and not from the regular appointment on 12/8/2013. The aforementioned order of next paragraph. The aforementioned order of the tribunal was questioned by the has been questioned by the petitioner. On the ground that when the original appointment letter and its continuation on one or two occasions specifically intimated the respondent that such appointment shall not be treated as a precursor to regular appointment or would not be added for the purposes of seniority or any other benefit, the tribunal definitely fell in error in directing for counting of ad hoc tenure of the respondent as a regular service. It was only a temporary fix for urgent need without conferring any right of regularization or other benefits like seniority. Contention also was raised on behalf of the petitioner that the appointment of the respondent was not in consonance with the standard recruitment rules of 1989, which required selection by the SSC for regular posts. Mr. Nath, learned advocate for the respondent, however, disputes the aforementioned assertion and submits that the appointment may have been ad hoc or temporary, but it was in accordance with the rules. In accordance with the rules. The counter argument of the petitioner is that it is very obvious from the extension of the service of the respondent that it was granted as one of the SSC recommended candidates had not joined. It was further contended that the respondent had accepted the terms of ad hoc extension, which also clearly stipulated that such ad hoc tenure would not be counted for seniority or promotion. The concern of the petitioner is that with the direction for counting of the ad hoc services of the respondent, unfairly affect the seniority of other employees who have come through the SSC channel. Devi, learned advocate for the petitioner, however, informs this court that the respondent has now been promoted to the post of upper division clerk under the normal channel of promotion. For the interim order passed by the tribunal, the respondent was permitted to appear in the limited departmental competitive examination, which though was concluded and appointments were made, but one post was kept reserved, awaiting the final judgment by the tribunal. That post still remains vacant. Mr. Nath, learned advocate for the appellant, for the respondent, submits that this regular channel promotion does not satisfy the respondent as it adversely affects her seniority. In the limited departmental examination, where she had appeared under the orders of the tribunal, under the interim order of the tribunal, she had qualified, and with one seat having kept vacant, she ought to be promoted against that post which was for limited, against that reserved post which was notified for the limited departmental competitive examination.
Lordship, may I submit? Lordship, as per the vacancy position, there were.
अरे आप छोड़िए तो सही है, we are rejecting this.
Beyond vacancy position, she was promoted, Lordship. After retirement of one of the senior assistant, Lordship, she was adjusted against this post.
What happened?
Lordship, there were three senior assistant posts, Lordship. After that, she was promoted. But since there was no post, she was.
तो आपने अभी बताया ना, you only said that one post was kept reserved because
at that time, Lordship.
At that time, but now there is no vacancy. You should say that openly, no? So why are you bothered? You should have said that. क्या लिखा? फिर again I'll have to go back. You will not remember. कहाँ से लिखा वन? बड़ा मुश्किल. I had qualified. उसको काट देंगे हम. The contention of Mr. Nath is that by no stretch of imagination can her appointment in the year 2000, can the appointment of the respondent in 2011 be said to be a stopgap arrangement, even though it was ad hoc or temporary. The stipulation in such orders were accepted by her, but then the law protects her ad hoc tenure to be counted as regular tenure for the reason of the appointment having been made through regular channel of SSC in consonance with the rules in that regard.
Lordship, she was not appointed through SSC.
Rules in that is his submission. We do not approve of such submission on the plain ground that in several decisions of the Supreme Court, including State of West Bengal versus Agornath Day, 1993, 3 SCC 371, Secretary, Minor Irrigation Department and others versus Narendra Kumar Tripathi, 2015, 11 SCC 80. Can an appointment on ad hoc or temporary basis be converted into a be counted as regular tenure when the specifications in such appointment letter in the beginning clearly indicates that it is a temporary appointment giving no right to claim for regularization or for seniority. Now that the respondent stands promoted to the post of upper division clerk, we do not wish to get into that issue any further. First up. For the reasons recorded above, we find that the directions given by the tribunal was unwarranted and uncalled for and deserves to be set aside. We order accordingly. The order passed by the tribunal is set aside. First up. We say no further. Chalo.
Item 32.
ये क्या है? अब क्या है? Committee after the Supreme Court's judgment, after our judgment, you went to Supreme Court. Supreme Court did not interfere with our judgment. Supreme Court only said that let a committee be constituted. Is that correct? Committee was constituted. They found that you are required to be evicted. You were evicted. Evicted or notice issued?
My lord, the process for eviction is going on.
For eviction is going on.
It is-
Then you challenge that decision of the authorities before the single judge who has rejected this. अब क्या करेंगे?
Interim
Huh?
interim order rejected on a, my lord, tentative
No.
tentative view, my lord.
No. Let you go and decide before. Let the issue be decided by the learned single.
We are filing affidavit on Monday, Tuesday, all cases.
My lord,
Make a request. We permit you to make a request before the learned single judge.
Yes. 7 other cases are fixed.
That is fixed on Tuesday.
Tuesday.
my lord, coming Tuesday, but these batch, my lord, there were two batch.
Sorry, sir.
My lord, may just, there for a moment.
अरे ट्यूसडे को आपकी जब सुनवाई हो जाएगी तो एंट्रीम ऑर्डर के खिलाफ हम क्यों आएंगे यहाँ? क्यों अपील सुनेंगे?
My lord, the interim, my lord is adjourning.
I made a statement for honorable single judge that till the elections we will not appeal. That's why it is fixed on 7th, my lord.
No, this batch was rejected, my lord. These, my lord, two batches were there, my lord.
इसको ऐसा
On
कर
this
सकते हैं।
batch,
सिंगल जज कैंसिल लेकर हम ही फिर सुन लेते हैं। खत्म हो जाएगा मामला।
my lord, my lord, may I pray, my lord?
Yes.
My lord, may I pray, my lord, that the another batch is fixed on coming Tuesday on 7th, my lord.
You don't want this matter to be argued and completed before the learned single judge. Why are you insisting for it? If you want it to be tied up or tagged with another case, we would be very happy to do that. But we shall not interfere even by a letter against the interim order.
My lord, if in the meantime we evicted, my lord, then whole petition will become infectious.
Did you not hear what additional
My
advocate general just
amendment is saying in another batch, my lord, not in
I'm
this
saying
case.
in these cases also.
My
Till
lord,
elections we
then,
will
my
not
lord,
appeal.
his submission may be recorded and my matter
Take
can
that.
be closed, my lord.
And maybe fixed on 7th.
the appellants had prayed for revisit to the decision of evicting them from so-called government lands, the so-called forest lands, pursuant to the forest land. क्या लिखा है? The appellants before the learned single judge and had sought interim protection, which was refused. The learned counsel for the learned additional advocate general, Mr. Goswami, Mr. P. Goswami, learned additional advocate general, submits that before the learned single judge, it was averred on behalf of the state that the writ petition shall be replied until the final decision, no eviction would take place.
My submission was still elections, my lord.
Till the elections, no eviction shall take place. Full stop. The matter is the learned single judge, after refusing the interim prayer, directed the matter to be listed on
7th, my lord.
on 7th of April. Full stop. Mr. Goswami, learned additional advocate general submits that before that date, the affidavit on behalf of the state shall be filed. Full stop. In that view of the assertion, in view of such clear statement by the additional advocate general, Assam, that no eviction shall take place in the elections on 9th of April, and the single judge having fixed the date of 7th for hearing of this petition, we do not find any necessity of even looking at the facts of the case for questioning the correctness of the order refusing the interim prayer. The appeal stands dismissed.
Close, my lord. Obliged, highly obliged.
Daily list for hearing item 28.
Very well. Gauhati University, Babu, कौन आ जाएगी? Yes,
May I please?
we'll hear you after lunch. If you intend to finish it in 5 minutes, all right. Otherwise we'll.
It will take some time, at least 15, 20 minutes.
So we come back at 2. Do you? Okay.
Item 26.
My lord, presently I will deal with the point which my learned friend has raised regarding that he should get 17, I should get 15. I'll show from his own writ petition. my lord,
Mr.
that-
Chaudhary, did we not ask you about our view
Yes.
and your perception?
That's why, my lord, thereafter, even after that, if your lordship thinks that single judge's order should be maintained and matters should be remanded, lordship will do that.
No. We are not for that determination. Let it be done afresh with more people who could be considered.
Well, that will
The
be
reason is-
virtually an end for me, my lord.
That is different, but this also would be an end for you.
No, this perhaps won't be. Only thing is, my lord, his submission is because why he has filed this subsequent petition, because according to him, I should get 15, he should get 17. These are the paragraph.
If that be so, then if the single judge has
No, my lord,
remitted the matter
learned
for
single
consideration.
judge proceeded on a wrong premise. My lord, what had happened? When the matter was heard by the other single bench, my lord, the understanding was we filed an application for vacating stay. Then the learned single judge was of the view, instead of that, we will dispose of the writ petition and my IM will be treated as my affidavit in opposition. But at page 336, the learned single judge says that we have not filed affidavit, therefore the statement remains unrebutted. Please have a look at page 336, my lord.
No, that we don't take into account.
No, please have a look, because that is what has will not influence the decision. Page 336. 6th line from top. A perusal of the affidavit in opposition goes to show that the specific pleadings made in the writ petition have not been rebutted, and only that the writ petition is said to be barred by principles of constructive res judicata. As already noticed, in view of the marks having been revisited, this court is of the considered view that principles of constructive res judicata cannot be said to be attracted for the reason already stated earlier. Therefore, having regard to the peculiar facts and circumstances of the case, this court is of the considered view that specific allegation made by the writ petitioner that marks have been wrongly awarded to respondent number 6 in violation of the relevant guidelines, including OM dated so and so, remains unanswered, therefore requires to be considered and re-examined.
एक तरफ का कहीं AC कम करो, बहुत ठंडा लग
My
रहा
lord, if because of non-filing
है. 1
of
second, sir. AC कम करो एक तरफ का, ठंडा लग रहा है.
On account of non-traversal, the statement should have been accepted. Where is the question of, my lord, taking this view that it merits, my lord, reconsideration? Now let us come to his writ petition and what is his case.
Now, could you please place paragraph 16 of that judgment at page 335?
336, my lord.
335, paragraph 16.
Yes. I have heard the learned counsel for the rival parties and I have perused the materials available on record. Sri so-and-so learned counsel has questioned the maintainability of the writ petition on the ground that it is barred by principles of constructive res judicata, since the writ petitioner had already abandoned the second prayer made in this writ petition, that is WPC, by not raising any objection, despite the court having not decided or considered the said prayer when the writ petition was disposed of on 19/6/23. It may be seen that the second prayer of the petitioner was for quashing the impugned statement of marks dated 15/6/19, prepared by the selection committee of the school, whereby respondent number 6 was said to have been illegally awarded extra marks and placed in the first position for the post of principal of the said school. The marks scored by the writ petitioner was 18, while the respondent number 6 scored 20.
Here, respondent number 6 was you.
No, Miller. Respondent number. While
There was.
Oh, yes. I'm sorry. Yes. However, the fact remains that WPC was listed on 11/9/23. Learned counsel for the department had produced the relevant record, where it was revealed that both the writ petitioner as well as respondent number 6 were given 617 marks each. Therefore, it can be seen that earlier statement of mark dated has since been revisited, and writ petitioner agreed with the marks given to respondent number 6 as 17, and which is equal to the marking given to him had initiated WPC so-and-so. Specific pleading with regard to irregularity of the marks given to respondent number 6 has been taken at paragraph 13, 14, 15, and 16, including violation of the guidelines for selection of so-and-so, so-and-so. So these paragraphs I have also said, my lord, this gives them the furnishings in the cause of action. Now, my lord will kindly come to the circular and the marks. That is his writ petition pleadings. Please come to, my lord, page number 242. Yes. This is the circular which, according to, my lord, respondent number, the other side, my lord, is violated. My lord, first column is leadership skill. Maximum one can get 4. And my lord, how it will be given? Result of higher secondary Assam higher examination in case of graduate teacher.
No, where are you reading? Page 242.
Yes, my lord.
241, not 242.
41. Oh, I'm sorry. A leadership skill 4 marks. Result of HSLC AHM examination in case of graduate teacher and higher secondary final examination in case of postgraduate teacher in school where he is a teacher. Result of the preceding year of selection, result of compartmental should be excluded. Now it works out like this, my lord. If pass percentage is 59%, then 1 mark. If pass percentage is 60 to 79, it is 2 marks. If pass percentage is 80 to 89, then 3 marks. 90% and above 4 marks. Here in this case, my lord, I'll show, my lord, why right mark has been issued. Then second is administrative ability. There are total 3 marks. Award marks, state award 1 mark for national award or both state and 2 marks. Award honors begotten by the school in students, teachers in academic, sports, social, cultural event organized in the state or national level by any organization of the government or private.
That's all right.
1
So,
mark.
after the revisit of the marks and giving both of you 17,
yes.
Where is that?
Yes, previous piece. Sajal Kumar Das is the appellant, my lord.
Page?
Page previous page, page two
हाँ,
forty.
but that is absolutely illegible. ये कैसा copy? अच्छा, हाँ.
Has your lordship got it?
Yes.
Yes. Now kindly see, this is on 26/11/2020, my lord. Now,
Then that's on 15/6/2019.
no, my lord. Interview was held on 15/6/1990. This is the second one. There is a
26/11.
signature down below.
Okay.
Now kindly see, my lord, HSLC pass percentage is 73.88. Therefore, I am entitled to 3 marks. Then, my lord, in a higher secondary, it is 49.4%,
Your percentage is what?
49.55.
In HSLC?
No, in HSLC, my mark is, my lord, 73.88.
73.88. It's type.
On top, my lord, yes.
It's type 23.88. Anyway,
Then SSLC, that is higher secondary, 49.55. BSc 39.21. MSc 47.2. B.Ed 43. So I got 8 marks, my lord, as per that circular. Then as far as the other party, Mr. Majid Ali is concerned, my lord, in HSLC, he got 48.25. MA, he got 39.2. Then, my lord, HSLC 39.2. BA, he got 42. MA, he got 45. BF 71. So he also got 8 marks. As far as academics.
he got 9 marks.
8, my lord.
No.
You have typed wrongly.
My lord.
In your type copy, it is wrongly typed. It is 8.
8.
You have typed it now.
Oh, no, type copy is wrong. Original is the other.
Original is absolutely, mine is totally illegible. Anyway, you have a copy, clear copy?
My lord.
Mr. Saike, you have a clear copy? Just, if you have a pullout, please give it to us. The same thing.
No,
That we can't.
This one is better than the what is the election dedicated. No, this is, I think, legible. No, there is no dispute that both of us got 8 on academics.
That's true, but then the type copy should have been. This is better.
Madam, just before proceeding further, madam, what I'd like to point out, madam, for the purpose of leadership, madam, determination, for postgraduate teacher, it will be result of the higher secondary alone. Result of the higher secondary.
How do you say?
Because Lordship will see the 241 that
And higher secondary final examination in case of postgraduate.
result of HSLC
that requirement.
examination in case of graduate teacher. And
HS final examination in case of postgraduate.
In case of postgraduate teacher in the school where he is a teacher. Now here we all are the HS and the postgraduate teachers. So it is the result of the preceding year. Naturally. And the preceding year your lordship will find. So my learned friend will get this appellant is lordship.
Yes.
So, my lord, as far as academic mark is concerned, both got 8 each. Now, please come to the next. As far as award is concerned, nobody got. As far as articles are concerned, both got 1-1. Now, my lord, experience is concerned. I have 23 years of experience. I have been given 3. He has got 23 years of experience. He has also given 3. Then, my lord, the in-charge principal, nobody got any mark. ACR, my lord, we both got 2-2. So it is 17-17. What is the infirmity in it? What has been pointed out in the writ petition? Why it is wrong? Why this marking is wrong? Which paragraph? My lord, writ petitioner has to lay the foundation. I'll read para 13, 14, 15 and 16. Other than making that he should not have got, what is that point which he has brought out? Yes, he discovered that during the pendency of the earlier writ petition, when records were given for inspection, he discovered it. But end of the day, my lord, it is the statement of marks you were agitating from day one, which you gave up. Now, my lord, let us come to para 13, 14, 15 and 16 of the writ petition, which is his case, which has been taken note of by the learned single judge also.
Para 13,
I'm coming to you, my lord.
page.
1 second, my lord. Page number 181, it starts, my lord. Please come to 197. Now, para 13, he gives a preface. Please come to para 14. Page 197. That the petitioner begs to state that the state selection board has illegally awarded 17 marks to the respondent number 6. That state selection board violated the norms as stipulated in office memorandum. That the state selection board had awarded 3 marks to respondent number 6 in leadership skill, but the respondent number 6 is eligible for 2 marks only as per guideline. Respondent number 6 is a postgraduate teacher and pass percentage of the school in the higher secondary examination in the preceding year, that is in so-and-so, is only 76.28. Therefore, as per guidelines, he is eligible for only 2 marks, but he has been illegally allotted 3 marks. That the petitioner further begs to state that selection board has illegally awarded less mark to the petitioner in the leadership skill. That petitioner was awarded 3 marks in the leadership skill, but as per guidelines, petitioner is eligible for 4 marks. That the interview for the post of principal was held on so-and-so, and the pass percentage of the petitioner's earlier school in higher secondary final examination in the year was so-and-so. Therefore, as per guideline, petitioner should be given 4 marks instead of 3 marks by the state selection board. But surprisingly, the petitioner has been given only 3 marks, which is totally bad in law. Well, the same points were raised in the earlier case also. Same very statements. No. Only this time, my lord, instead of 20 and 18, it became 17 and 17.
But considering the fact situation, that's very similar. Maybe obviously is the indifference as well. Considering this, that's only 1.5 months past, they must come out with the process. Is a control any chance? Fresh selection. Derailed high. That's a reasonable claim. किसी को हम recalibrate कर सकते हैं. You know, you will also get an opportunity to use the tabs. We want the suspension. We will get it after returning the No, I know. No, I also get it. Show us that constructive res judicata judgment.
Yes. My lord, first lordships will kindly have this Modi's judgment, my lord. Modi's judgment is at page 46 of the compilation, my lord. My lord will kindly come to page 49.
Page 46.
Page 49. Para 10.
Yeah.
In regard to orders of assessment for different years, the position may be different. Even if the said orders are passed under the same provision of law, it may theoretically be open to the party to contend that liability being recurring from year to year, the cause of action is not the same. And so even if a citizen's petition challenging the order of assessment passed against him for 1 year is rejected, it may be open to him to challenge a similar assessment order passed for the next year. In that case, the court may ultimately adopt the same view which has been adopted on the earlier occasion. But if a new ground is urged, the court may have to consider it on the merits, because strictly speaking, principle of res judicata may not apply to such a case. That, in fact, is the effect of the decision of this court in Amalgamated Coalfields versus so and so. In that case, this court had the occasion to consider the question about applicability of constructive res judicata to the proceedings taken by appellant, the Amalgamated Coalfields, challenging the tax levied against it for different period. The petition first filed by it for challenging the validity of the tax imposed against it.
Now, why have you referred to this decision? This makes a distinction. It says that it is an artificial construct under section 11 of the.
No, my lord, I have placed the judgment only for the proposition that even in a proceeding under 226, this principle applies.
No.
And there's one more thing, my lord. Here, what was held was, in respect of the different assessment year, you cannot come up with a new ground in the subsequent assessment year.
No, that's all right.
Yes.
Look at the position of law with respect to constructive res judicata in a writ jurisdiction.
Yes.
Now come to page 50.
Yes, my lord.
Second
para 11.
Para 10 only.
In our opinion.
In our opinion.
The said general observations must be read in the light of the important fact that order which was.
Where are you reading? No, accordingly, from the second line.
Okay. Accordingly, the merits of the said points were considered, and in fact, the said points were upheld. In dealing with the question of constructive res judicata, this court observed that constructive res judicata was an artificial form of the res judicata enacted by section 11 of the CPC, and it should not be generally applied to writ petitions filed under Article 32 or 226. It was in that connection that this court also pointed out that the appeal before the court was in relation to assessment levied for a different year, and that made the doctrine of res judicata itself inapplicable. Mr. Trivedi contends that in dealing with the writ petitions, no distinction should be made between cases where impugn order of assessment is in respect of same year or for different years, and in support of his contention, he relied on the general observation made in so and so. In our opinion, said general observation must be read in the light of the important fact that the order which was challenged in the second writ petition was in relation to a different period, and not for the same period as was covered by the earlier petition. As we have already mentioned, though the court dealing with the question of infringement of fundamental right must consistently endeavor to sustain.
The only
this-
difficulty is that it is with respect to sustaining the fundamental rights.
Yes.
This is a right of yours to be considered, not a right. It's not a fundamental right. For so far as this is concerned, I mean, we were going with you so
Yes.
far because all this while the matter of selection of principal, you know, it was hanging fire because of his opposition. Once he was appointed, then
Everything was hunky-dory.
once he was appointed and then he was reverted back also. Then he questions everything. Now
It is in that context.
it is in that context, but now there is no specific application of constructive res
No,
judicata.
because this judgment actually lordships indicated the other day, get this Modi and all, that is how I have come. But it is only for the proposition, my lord. This is an appropriate case. In a 226 petition also, this principle applies. Otherwise, my lord, the better judgment should be, my lord, this one.
Dariao.
Dariao. Dariao is, my lord, page 35, page 30.
Well, the difficulty is this. The paragraph 11, you know, makes a distinction, sub
Yes.
silentio, that it says about fundamental rights.
Correct.
And it was through, this is just for understanding. I mean,
Yes.
this way or that way.
May not have a direct bearing, but to understand what the law on the subject.
What the law on the subject is.
Now, my lord, para 35, page 35, my lord. After referring to Ramesh Thapar and all, last 6 lines of para 8 at page 35. Thus, the right given to citizen to move this court by petition under Article 32.
Yes,
And-
sir, again, you-
Sorry, my lord.
This is again, yes, we have right, 32, claim and appropriate.
It was in the context of 32. And claim an appropriate writ against the unconstitutional infringement of his fundamental right itself is a matter of fundamental right.
No,
And in dealing with
please.
objection,
I think we should read para 9.
yes. But is the rule of res judicata merely a technical rule, or it is based on high public policy? If the rule of res judicata itself embodies a principle of public policy, which in turn is an essential part of the rule of law, then the objection that rule cannot be invoked where fundamental rights are in question may lose much of its validity. Now, the rule of res judicata, as indicated in section 11, has no doubt some technical aspect. For instance, the rule of constructive res judicata may be said to be technical, but the basis on which the said rule rests is founded on consideration of public policy. It is in the interest of the public at large that a finality should attach to the binding decisions pronounced by the court of the competent jurisdiction. And it is also in the public interest that individuals should not be vexed twice over the same kind of litigation. If these two principles form the foundation of general rule of res judicata, they cannot be treated as irrelevant or admissible, even in dealing with the fundamental rights in a petition under Article 32. So even
So therefore, primarily it was limited to Article 32
Yes.
fundamental right.
Yes, correct.
We can't tinker with the law.
Yes. No, my lord, when Article 32 itself being a part of the Part 3 of the Constitution,
That's right.
when
Here-
it was said, even when you are trying to enforce your fundamental right, then also you are to follow. Then my lord will kindly come to this judgment, my
No,
lord.
para 10,
Kesharam,
no, para 10 also, let us
Yes.
see the background.
in considering the essential elements of res judicata, one inevitably harks back to the judgment of Sir William B. Hale in leading Dutch versus so-and-so. Said Sir William B. Hale, from the variety of cases relative to the judgment being given in the evidence in civil suits, this two deduction seems to follow as generally true. First, that judgment of a court of a concurrent jurisdiction directly upon the point is as a plea, a bar, or as evidence conclusive between the same parties upon the same matter directly in question in another court. Secondly, that the judgment of a court of exclusive jurisdiction directly upon the point is in the like manner conclusive upon the same matter between the same parties coming incidentally in question in another court for a different purpose. As has been observed by Halsbury, the doctrine of res judicata is not a technical doctrine applicable only to records. It is a fundamental doctrine of all courts that there must be an end of litigation. Halsbury also adds that doctrine applies equally in all courts and it
Yeah.
is immaterial in
No,
what
no,
court.
the punchline would be here.
Yes,
Now, please come to paragraph. The same, the page number would be 27. 27. Come to the 10th line, just count 10th line from the top
yes.
on page,
My lord, this is which judgment?
page 27, same judgment.
New Bihar.
Uh,
No, this is a different judgment, New Bihar.
No, 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 no.
My lord,
Same judgment what you are reading, Darya only.
Dario.
Page 27, page, sorry, 37. I'm so sorry, 37.
Para 19, my lord.
No, para 19 is in the second, in the later part. Now,
In other words,
from this rule is subject to the top line 10th. 1, 2, 3, 4, 5, 6, 7, 8, 9, 10. This rule.
this rule is subject to limitation that judgment in the former action must have been rendered by court or a tribunal of competent jurisdiction. Yes.
Correct. So it does not say that by necessary implication, that issue was decided.
Yes.
Now, question is that issue was never decided. The
Never.
court took it upon itself to decide it, to remit it on a different issue altogether. That issue was not decided.
Yes.
Now, then it is,
however, essential that there should have been a judicial determination of rights in
of controversy with a
the
final decision thereon.
therein.
So therefore, here we are just testing the law. I understand you're not going to benefit much. He's also not going to benefit because he is under suspension.
Yes.
Now, this would not be a decision which would help either of you straight away. But let us understand the law.
Yes,
because it was not fully determined. The only question was that it would be deemed to have been determined. Now, whether that rule with that inference of the construction could be applied in a case where the matter was remanded on a typical issue without abandoning that issue altogether, it can only be presumed that the issue was abandoned and he accepted it.
But one has to presume that he has abandoned
Therefore,
that relief.
and that keep in mind, Mr. Chaudhary.
Yes.
I'm keeping it in mind that
I have followed, my lord.
it does not relate to any fundamental right.
Correct.
So if that would be pressing a jurisdiction, pressing a theory of law which does not collocate with this, with Daryao.
No, well, subsequent judgment clearly says, I'll come back.
Okay.
Anyway, it is, however, essential that there should have been a judicial determination of right in controversy with a final decision thereon. In other words, original petition for a writ under Article 32 cannot take the place of an appeal against the order passed by High Court in a petition before it under Article 32(26). There can be little doubt that jurisdiction of this court to entertain application under Article 32, which are original, cannot be confused or mistaken or used for appellate jurisdiction of this court, which can alone be invoked for correcting errors in the decision of the High Court pronounced in writ petitions under 226. Actually, what had happened?
No, next line helps.
Yes.
You.
Thus, on general consideration of public policy, there seems to be no reason why rule of res judicata should be treated as inadmissible or irrelevant in dealing with petitions filed under so and so.
Correct. So therefore, it is applicable to writ jurisdiction, we understand. But whether it would be applicable here when there was no judicial determination over the issue.
Look, primarily, my lord, I think that
by inferential logic.
No, look, primarily my humble submission is Darjo was dealing with res judicata, not with constructive res judicata, with respect to what I'll say. Thus, on general consideration of public policy, there seems to be no reason why rule of res judicata should be treated as...
As you proceed further, the difficulty, then it says,
it is true that general rule can be invoked only in cases where a dispute between parties has been referred to a court of competent jurisdiction.
Number
There
one,
has been a
eh,
contest.
Just a minute. There is a reference to the court of competent jurisdiction, that is filing of that petition with that prayer.
Yes.
There has been a contest between the parties before
Parties,
the court.
uh-huh.
A fair opportunity given to both of them to prove their case.
And at the end,
And then at the end, the court has pronounced its judgment or decision, which is not the case here.
Yes. Such a decision pronounced be a court of competent jurisdiction binding between the parties unless it is modified, reversed by adopting procedure prescribed by the Constitution. In our opinion, therefore, the plea of the general rule of res judicata should not be allowed to be invoked and cannot be sustained.
In writ jurisdiction, it has to be allowed.
Yes.
This explanation only gives an inkling about actually framing this this artificial legal construct.
Reading para 18, my lord, what has fallen from your lordship is absolutely correct. But in my humble understanding, subject to it, your lordship may say, in Darjo's case, my lord, the Supreme Court was considering the meaning of res judicata, not constructive res judicata. There is a difference between res judicata and a constructive.
That's all right. Res judicata is not directly applicable, constructive res judicata.
Constructive res judicata is slightly different, my lord. Here, even if a point ought to have been asked, not asked, then also it will be treated as a constructive res judicata. That's my humble understanding.
Yeah, that is the only answer which you can give. Yes, no, that's the only answer.
Now, my lord, please come to this judgment, which will make the position clear. Now, please come to Keshoram case, my lord, at page 52. I'll have your lordship's kind attention to page 60, para 10. This is directly dealing with constructive res judicata. Para 10 at page 60 of the compilation.
Yes.
Before we consider the submission made on behalf of the tenants, we'd like to point out that some of the tenants who were unsuccessful before this court in Punjab Teen have again filed petition challenging the validity of Section 3 and the impute notification on additional grounds. In our opinion, the petition by such tenants are not maintainable, as the same are barred by the principles of res judicata. Once the petitioner challenged the validity of the impute notification in an earlier proceeding, they ought to have raised all grounds which could have been raised in impugning the validity of Section 3 and notification. And if they fail to raise a ground in an earlier petition, they cannot raise that ground now in the present proceeding.
So therefore, it is res judicata, not constructive res.
Yes.
Because that was raised and not contested.
Not contested.
That can be the argument of Mr. Saikia, that
Yes.
it was raised, not contested, and the court chose to ignore that, remit the matter on a different issue.
Yes. Finally,
which normally you do. Suppose you government decides not to give you license of on shop, right? You come before this court says that no, it is within the domain of the administrative decision making. You go back and file another petition challenging the validity. Could it be stopped on grounds of constructive res judicata? It could not be, because you are questioning the validity of the act itself. Now there,
when it comes to challenging validity, this principle does not apply.
Correct. So therefore, the same logic applies that you may have pleaded that, you may not have pressed it.
No, here in this case, lordship will, end of the day,
I understand.
In the peculiar facts of the case, lordship will.
In peculiar facts of this case, we are inclined to adopt this principle of res judicata / constructive res judicata, for the reason that 7 years time has been consumed in all this litigation, only with respect to marks. And why should we revisit the marks?
Correct, we have followed. Definitely that is one way of looking at it. But our predicament is, my lord, our client is retiring in July. And he could not enjoy the benefit of his selection.
But principle nahi lagayenge, because that is something else. We'll let him.
Anyway, now what I'm trying to say here is, now we will kindly see the conduct of the petitioner. When he files the first writ petition, he suppresses the fact that the marks were examined and it was made known to everyone. Number one. Number two, my lord, thereafter, when the appointment was given to him, when I laid a challenge, his case is the selection is good. Selection does not suffer
On
from
the
any
same set of marks.
same set of marks. Now kindly see that portion, my lord. It's so important in this case.
It's okay.
Just 1 minute, my lord. MBB, yes. Page
Tell me one
29, my
thing,
lord.
tell me one thing, with only 1.5 months for you to superannuate,
Yes.
if we issue a direction, we talk about res judicata and all that, but we say that since this direction has been given and it is pending before that authority, let the authority decide the case within a week, and pass an order, and the consequent order also shall be passed, which shall not be subjected to any, which ought not, which perhaps would be the end of the matter. We will not say it cannot be questioned.
No,
We will only say which perhaps would be the end of the matter.
Eventually, lordships will pass the order. Our duty is to
No,
persuade your lordships to take a particular view.
Correct, Mr. Chaudhary, you have made a dent in our earlier thinking, because we can't ignore that principle that a point which is abandoned would be deemed to have been taken up and decided. But it was not even given up. The court merely remits it on that issue, on one issue, because that issue was left open. Suppose the court would have said that we are remitting it on that issue, the other issue is left open.
Things would have been different.
Things would have been different. So can it not be read as invisible statement in that? I mean, there are many things. If you start stretching the logic, it could end anywhere. Therefore, I am suggesting the only via media which we can think. Of course, our duty is not to mediate in every matter. But considering the fact, now, many a times as lawyers, we used to adversely comment on the bench, appearing as lawyer, where the bench wanted to mediate. Right. Those were the days when mediation had not attained that kind of a recognition, that kind of acceptability and sanctity. So we always used to say that what kind of court is this? This is like panchayat trying to panchayati. This was my usual refrain, where I thought that I had a point and that should be decided. But now the situations have changed. Mediation for the nation,
Section
even in
89
service
has assumed a different importance, my lord.
Different importance, a very high pedestal has been given internationally, even in service matters.
Yes.
And every conference they say,
considering the population and the judges ratio in this country, that perhaps is the
therefore,
only solution.
with this background, I am suggesting that if we sort of issue a direction in this appeal, for the authorities to take a call and immediately do a sequel action of it. He will otherwise not be appointed unless we hear him. He is under suspension. Suspension has been revoked.
No, I have never been suspended, my lord. I have never been suspended. My lord, because of government will clarify, my lord.
Yes.
My lord,
Is he under suspension?
Madam, his own affidavit.
No, just a minute. Is he under suspension? Let us have the facts from the government. Are you ready? Are you? What will you verify? This is today we are supposed to deliver the judgment today. No, but all facts, no. Huh? When? Can you verify on telephone? Can you verify on telephone, please? What is it?
My lord, please come to page 319. Read the report of so and so, so and so. The lordship may kindly skip this. These are the allegations. Please come to 320. Not providing midday meal and all these are the allegations. In view of the above facts and circumstances, following orders are hereby passed. Inspector of School Borbeta is hereby directed to take initiative to audit the government grants allotted to Bangdungra during the tenure of Majid Ali, and shall submit report to the undersigned on receipt of the audit report from the concerned authority. Till completion of the process, Majid Ali is hereby debarred from his duties and responsibilities of principal of the school, and thus Majid Ali, principal, shall not exercise financial power of the school.
Not suspension. He's debarred
But
from
his
holding.
financial power has been taken. Debarred.
That is a correct statement. Financial powers have been seized.
Further in the service, inspector will temporarily have to act as a principal in charge.
ठीक है.
It is only in November 2025.
Along with that. And this order has, see, there has not been any report. Audit is complete.
Yes, so this is completely
So
submitted.
have you taken over the charge?
But that
Has the financial powers been restored to you?
not
No,
fully.
then you can't be given the post. You can't be given the post. Why are you objecting?
No, my lord, there is
Why
one
I
more
have
thing, my
technical
lord.
with regard
Where
to
is
this?
the order? After that order,
After the
I was
reversion.
made the principal and he was rewarded back to his parents' school. Where is the order to? Because stay order doesn't revive the, and cannot revive an order which does not exist. Stay order was a stay order in respect of me to act as a principal. Now, how can he become a principal? Let my learned friend show that he has got any order. By that order,
All right.
anyway, my lord, I leave it to your lordship, my lord. My only submission
See,
is, my lord,
we'll ask him to take a final call within 10 days.
10 days.
Within 10 days. Are you ready? Decide.
Election में की होता है?
10 days doesn't matter. Even otherwise also it will take some time for you to be appointed.
Whenever there is an order by the High Court, there is no election commission is coming in.
No, this will not come in
Yes,
election.
yes.
Commission. This is not under the, you decide within 10 days. And the sequel order also. And we will indicate all this. Correct? Yes. Yeah, Mr. Saikia, not that we don't want to hear you, but here your financial powers have been seized. You ought not to enter into the premises. What happened? It's free. It's his view is
So far as
it's problematic. It is not working. It's problematic as it freeze. Mr. Saikia, the difficulty is this. Where is the order of stay of reversion of your position to that of the senior teacher?
Yes, my lord. I have, lordship, may kindly take up, my lord, I have given in detail.
No, you tell us, you show us, then perhaps that ground we will not take.
Lordship.
Don't ask us to go through the pages. You tell me where is we have you stated.
So many papers.
This is in deference in respect of the order passed by the learned single judge, because otherwise constructive res judicata we can squarely apply here.
Why, my lord, on that, my lord, my submission would be, my lord,
And then you have been, your conduct creates an impression that you have managed to keep the matter pending.
because of, my lord, his submissions, my lord, because of his submissions. Now, so far as, my lord,
And how do we do? What do we do with respect to? We will have to record his submission also that they want a fresh exercise so that more meritorious candidates would be considered.
my lord, he has allowed all these proceedings, my lord, 5 cases, my lord, petitions have been filed. At no point of time he has ever, my lord, participated.
Maximum number of writ petitions have been filed by you, Mr. Saikia.
Because government is not, my lord, I am fighting against the government, my lord. Every time this court passes on, my lord, favorable order, this is, my lord, again reverted, my lord, comes up with a different. There are specific directions to do the things in a particular way. My lord, first-
Where is the order of stay of that reversion? Then perhaps you're not appointed.
Yes, yes,
There has to be a specific order
Yes, yes.
appointing you.
Yes, I'll come to that. Give me some time.
Your appointment.
Yes, yes. My lord, page 106 of the writ petition.
Yeah, what is it?
Lordship. Read appeal. On the recommendation of the State Selection Board, Assam, and in pursuance of government approval accorded by.
Yes.
On recommendation of the State Selection Board, Assam and pursuant of the government approval accorded by letter dated so and so and subject to reversal without any notice, without estimating any.
No, I'm asking you something else. You're reading something else.
I am appointed.
You have been appointed.
Yes, that's what.
That is the order.
That is the order.
Page?
Page 106.
That is of 21.
Yes,
This is first.
it was never set aside, my lord. This is never set
It
aside.
may not have been set aside directly, but then you were reverted. That order is there. We have seen it in the file.
Page 354,
On the last order.
page 354. He is reverted back as a postgraduate teacher. Page 354, last.
We have
sentence.
recorded that in our introductory.
Order, yes.
That there, my lord, I'll just.
354.
Last two line, my lord. Further, Majid Ali is hereby reverted back. This was on 9/29/4/23.
354. Yes. No, your paging is incorrect. This is the order dated 29/4/2020.
Yeah, 23.
Yeah. Appointed as principal and Majid Ali is hereby reverted back to his.
Yes.
And this
That's
is
what I'm
this is
saying.
of
This
2020.
was-
After this, where was the order cancelling this reversion and making you principal?
Yes, my lord will find, my lord, this 29/4 order. 29/4 order was passed, your lordship will kindly see, my lord. My lord, this was passed pursuant to the, my lord, order dated 9/3/2023.
And now,
That 9/3/2023, this court has set aside.
no, Mr. Das, Mr. Saikia, please, not that. Where is the order rescinding the order at page 354?
My lord, 354 is not telling which mine, my lord, so far as read appeal is
Doesn't,
concerned.
the order dated.
His
order
order,
dated 29/4.
I 350, go to
my lord,
350.
his order appears with 29/4/23 appears at 213 perhaps.
No, page 350. Anyway, you read the order.
Yes,
29/4
it's the same
2020.
order 213.
230. So has that been modified, varied, rescinded, set aside, not set aside, changed?
I'll come to it.
चलिए अब बहुत देर हो गया.
Madam,
Have to
this
finish two
order
more
was
matters.
passed. This order was passed pursuant to the order dated 9/3. Lordship will kindly see, my lord, the 9/3 order
Correct.
at page 302.
We don't know. But now tell us, so many orders have been passed by single judges. Now, pursuant to any order passed by any court,
Gotcha.
where you show us any order which says that this order stands modified, this order is stayed.
My lord, that order dated 4/5/23 in WPC number 244 to page 33.
What does it say? Then mistake कर दिया तो इनको फिर देना होगा ना. Sequential order has to be passed, no? Suppose the High Court would have stayed.
215, Lordship, they can read 215.
Read it.
Yes.
इतना पेज ना पेज डालो.
Start from 216.
Mr. Saikia will not let it go. So therefore, it is better that we direct for a final decision by the authorities within 10 days.
No, Lordship, let us see. Page 220. May I read?
Status quo.
What is the status quo?
Lordship, may I just help for the.
And this order is passed, this order has been passed when?
19/6.
And that order was reverting you was passed on 19/3.
Status quo was given on 8/5/2023.
So it was after the order of reversion. After the order of reversion, where are you looking here and there?
Yes, yes,
After
yes.
the order of reversion.
Okay.
So this is status quo, not a status quo ante.
Status quo, my lord, till that-
Status quo means that he
Status quo-
remains the principal.
No, my lord, he has to join, my lord. He did not join. I was in the charge.
Is that you?
I was in the position.
No. And that in charge position also has been divested from you.
No, that is, my lord, only in November 2025.
Can you claim it?
3 months back.
Can't we say that you can't even claim it now, subject to the audit failings? I mean,
No, no,
what has
it has
been
been
found?
submitted now because of the election duties, perhaps one of the final order of reinstating, allowing.
No,
me to-
anyway,
that has not come.
we don't
That is-
require your concession now, Mr. Saikia. We have heard you. Now, I think.
I have not submitted my,
Why
case,
only-
because I'm trying to clarify your lordships, the order dated 29/4, my lord. So that 29/4 is on the basis of the, my lord, observation of 9/3. So this court has set aside that 9/3 order. Consequently, 29/4 has gone, my lord. That's what my page 220 is. I'll just read out, my lord. Paragraph 6.
Well, I will be
Being agreed with the order dated 29/4/2023 passed. Being agreed with the order dated 29/4/2023 passed by in charge director of secondary school Assam, petitioner is before this court on the ground that while secretary to the government of Assam Department of Education considered the matter, the judgment was misconstrued and not in conformity.
Can you claim this, Mr. Saikia? Now let me ask this question from you. This is just for our understanding because it should not have been entertained for so long. Now, your appointment is by virtue of your having obtained 17 marks, correct? Yes or no? Don't say no just like that.
No one.
You are appointed here only after there was a revisit of the marks allotted to the parties.
No one.
No.
But what happened? That's what I'm saying. My
You never, up till now, you have never got more than him. Wrongly or rightly, have you obtained more marks than him? Initially, he got 80, 20, you got 18. There was a revisit, there was a relook, both of you got 17. So in any case, your appointment was based on that marks. Did you question that marks?
My lord.
So therefore, your appointment also was based on that marks only.
That is the subject matter in the last writ petition, and this the honorable single judge.
I'm asking you, forget about the subject matter of particular writ petition. Now, you are holding on to that position. Suppose there was no status quo, there was no reversion, nothing of the kind. You are holding on to that position on the basis of marks allotted to you. Because in the meantime, he went off somewhere, then you obtained an order, matter was remanded. But that marks was the basis for you to be chosen. Amongst three, two of you were the main contenders and you were chosen. Can there be a departure from this position?
I'll just, Lordship will give me 2 minutes, I'll just make it clear.
Now you uninterrupted 2 minutes, 5 minutes, completed. Uninterrupted, will not ask you any question.
Lordship. My lord will find, my lord, the
orders tomorrow.
15/6/2019 school selection committee, as per the rules, they have prepared the marks where he has been given 20, I have been given 17. I have submitted a complaint before the state government that these marks are not in conformity with the particular notification. So therefore, revisit it. They did not do it. Rather, an inquiry was constituted. Inspector of schools was directed to do it.
Despite my promise, I am prompted to ask you one thing. Now, you would not argue if you argue only when we decide that it is a constructive res judicata, this direction, this remand is bad. Let him be appointed. That position, if we take, you object. But if we direct the authorities, because you have not filed any appeal, no, you're only a respondent. If we say that the authorities will decide it within 10 days,
yes,
you can't have any objection.
Gotcha.
We will not permit you to raise any objection on that.
Gotcha. Yes.
That's the end of the matter.
And as per the notification.
What as per the notification?
That notification from which the marks are given.
No. Whatever has
marks can be given. That is my whole case, that the marks are given not as per that particular notification, which is issued by the government.
It is only with respect to that.
They have to assign marks as per the notification.
So it is only for that the matter has been remanded, no? They do it within 10 days. Correct? Why? Same principle, same certificate, same percentage, you just have to recalculate.
Both for the records.
Record, no hearing is required. Then the whole purpose gets defeated, no? All right, 2 weeks.
Sometimes you need to do.
It takes 10 minutes. If you have all the records, you're the custodian of records. Take instructions whether it can be decided within 15 days. If you can't decide, then we set aside that order. Take a call. Take a call. We have heard no more argument is required.
That have been placed.
Hmm?
The view Lordship has taken, one view Lordship has taken, madam, that after his writ petition is disposed of, I have supported the
We
approval.
have taken one view that because of unnecessary or necessary litigation, the matter is hanging fire for 7 years. This is the only view which we have penned down. If we go by that rule, then both of you are ousted and you shall never get into the system because it will be a fresh exercise of selection. You want that view to be done subject to what because Mr. Chaudhary also would not be a great beneficiary. He gets 1 month, 1.5 months, nothing, but you have a longer career.
I have a longer career.
So therefore, the view which we have taken is that unnecessary time was consumed because of litigation. There should be a finality, and let there be, since so much of time has passed, therefore it is always better for the institution that a fresh exercise should be taken.
Lordship directs within 15 days to decide the matter as per the notification, my lord. And
What are we suggesting to you?
my lord?
What else are we suggesting
Yes,
to
my
you?
lord, that is, I'm agreeable to that, my lord. I'm agreeable to that.
नहीं वो सब नहीं कहते हैं. Whatever they decide.
They have been flouting this notification, which is the basis of assignment.
We'll say in accordance with the rules. We'll say in accordance with the rules. You want us to remand the matter saying that Mr. Saikia's client should be awarded more marks. I'm sorry, we can't do that.
I just pray only one word: rules and notification, etc. My lord, rules and notification, because that notification only guides the, my lord, upon the assignment of marks.
All rules in that regard: notification, order, rules, precedent,
Yes.
everything.
Yes.
देखिए, we have heard, इसको लिखा है, अभी लिखा है. My brother has. This is what happens now. लिखिए, order हम ये कर देते हैं, at home कर देते हैं. So this is what you do. We can't dictate it now because we have 2 other matters. My brother has to have another division bench. Or post arguments heard, post for judgment on Monday is what day?
6th.
6th at 3 p.m. No further arguments. Then in that case, we dictate it here. Otherwise it becomes very difficult. Then the matter, is kept in my office for long. Unless you dictate in the court. It's a 10-minute matter, we'll do it. Darya और ये सब रख देना. We are still sticking to that view that a lot of time has been consumed for this litigation. We are still sticking to that view. But considering all these aspects, we say that let it be decided within 10 days, an outer time limit, within 15 days. And you further seek instructions. All right, yes.
Item 28.
Not if you are there, it is all right, but if you are not there also, if there is some lawyer present, we'll do it. Mr. Fukun, what is the direction of the learned single judge?
Lord, to consider for regularization.
Consider. So you consider and reject. You say that it is part-time, it does not fall in the rules. Why are you challenging it? Consider. Consideration means you consider whether what is his name? Whether Mr. Sharma should be appointed as a regular teacher. Consider it, reject kariye. If that is not in consonance with the rules, why are you challenging it all? Take a call. We'll finish it. The order of the court. Consider, ask the authorities to sit, take a call, They can't. Part-time lecturer, they can't regularize. You can always consider for giving a fresh appointment, a regular appointment to her, provided her or him, her, provided she does not claim for the seniority from that date. You can take a call. You have an experienced hand, a part-time lecturer. Normally, law colleges have only part-time lecturers. Why don't you fill up that post by a regular vacancy, regular channel?
Already two advertisements were issued.
Uh.
She had taken part in those two.
She has taken part in those two,
The first
and
one-
she has failed.
The second one, Millard.
Why
stayed
can't
by
you?
this-
Why can't you do this? Ask the order of the single judge also would be respected. It shall be. Well, you decide. They don't say that please consider and appoint her. वो तो नहीं करते हैं. Consider करके एक speaking order pass करिए.
An earlier, Millard, a stay order has been passed, Millard. That order since 2018.
Are you understanding what we are telling?
Millard.
Ask the university if they are ready to consider. Otherwise, we'll say. I mean, you don't have a case, sir.
Difficulty is this one.
No, it doesn't apply. You're a part-time lecturer. It's not even ad hoc, no temporary. It's a part-time.
I was appointed on my lord, my workshop in my lord selection. my lord.
Maybe, but it is part-time.
My lord, I'm spending my lord almost 25 years, my lord. Till
We are-
I'm working.
We are sympathetic to you, but can we pass a judicial order regularizing your services? That is the whole
My lord,
difficulty.
Otherwise also, my lord, I am not eligible. My lord, I appeared before that, my lord, selection.
So let them take let them.
My lord, all the occasions, my lord, I have been rejected, my lord.
Now. she
You
is
may
in
not be as
another
good.
college.
But my lord, I'm.
You may, Mr. Sharma, you may not be teaching well
But 25 years I'm working, my lord, they have not, my lord.
because they're short of hands. They could have terminated your appointment, part-time status. No law college today has part-time lecturer.
But
They-
my lord, in the, Gauhati, so many part-time lecturers. My lord, in spite of.
She has already joined in another college, Millard.
My lord, in spite of specific, my lord.
She has already joined in another college.
And
She is
he-
not with you.
No, Millard. NEF Law College for last
No, my lord,
near
still
about.
working on it, as per my instruction.
No. You give that statement tomorrow.
Millard.
Give that statement on that score alone. We'll allow, they will set it.
As per my instructions, she is still working, my lord. Let me clarify now.
I'll clarify.
Consider career, you consider.
Can also be a ground. This can also be a ground.
पूछ लेगा. Just take instructions whether you want to consider her case. There is no necessity. I mean, there would be no, it would not be imperative upon you to decide it in her favor. You take a call, pass a speaking order. If she is dissatisfied, she will challenge it. If not,
Since
take
it's
that
a
instruction.
court's order, so.
Take that
is-
instruction. Take that instruction. Do we keep it tomorrow or after due?
My lord, next week, my lord, next week,
They're on,
Saying that you consider.
Take down. We have heard Mr. We have heard Mr. PJ Fukan for the Gauhati University / appellant and Mr. AK Sharma for which respondent? Respondent number 3 or respondent number 1? This is for respondent number 3. Mr. A. Goswami, learned advocate, has appeared for respondent number 3. This writ appeal is directed against the judgment and order dated 15/12/2022, passed by a learned single judge of this court in WPC number 5333 of 2015. The respondent claims to have been serving as part-time lecturer at the University Law College, the university. She has not been selected, appointed by the statutory selection committee constituted under section 15 capital A, read with section 13 of the Gauhati University Act 1947 as amended. The case of the appellant is that the stand of the appellant is that regular lecturers in the college have been duly appointed through this statutory procedure. Nonetheless, because of the respondent having rendered her services as part-time teacher in the Gauhati Law College, she approached this court seeking regularization of her service primarily on the ground that the Legal Education Committee of the Bar Council of India had recommended that part-time lecturers who have served for a long time should be regularized. By the impugned judgment, the university authorities have been directed to consider the case of the respondent for regularization. This appeal has been preferred on the ground that such direction would be contrary to the settled principle of law laid down by the Supreme Court and various other high courts regarding appointments and regularization, public employment. A perusal of the impugned order
Page 42. Sorry.
A perusal of the impugned judgment reflects that the learned single judge came to the conclusion that the respondent had made out a case for consideration of her case for regularization. We dispose of this petition, we dispose of this appeal by modifying the impugned judgment to the extent that the candidature of the respondent shall be considered for fresh/regular appointment. And in case it is not possible, the same shall be communicated to the respondent within a period of 30 days by a speaking order. We further clarify that any observation made in the impugned judgment with regard to the respondent having made out a case for a regularization shall not be taken into account unless the statutory rules permit for such a conclusion. The appeal stands disposed of accordingly. That's it.
Page 44.
At the time of my consideration, kindly make an observation that my experience may be counted.
Needless to state that while considering the candidature of the respondent, number one, her experience shall also be taken into account.
Lord, two aspects. Uma,
Why can't you pass an order that it is not possible or it is possible? If it is possible, give her the appointment. If not,
Lord,
forget it.
will solely based on Uma Devi, Lord. Uma Devi, Lord.
We have said something.
And
We have said without.
We have modified the order.
Yeah.
So next,
that page 44,
Attempt.
Lord, stay order is operating since 2018, Lord. Page-
what stay?
Lord,
In the
stay-
meantime, if the respondent number one is still rendering her service as part-time lecturer, she shall not be disengaged.
In
Lord, that That stay order is regarding selection process of 2018.
No.
It's 44, my lord.
There is a stay order.
That is.
Any order staying
Is 44.
any order staying the selection process in the meanwhile stands vacated.
Page 44, last para.
Stands vacated, finished. Okay, khatam. Any order if it is available. Chali, next.
Most of it.
Item 29.
May I please, Your Lordship? Am I audible, my lord?
You are audible, visible both, but Mr. Pukin, you seem to be in great, in love of patchy terms. We will hear you on some other date.
My lord, only some short date subject to convenience, my lord, because Your Lordships had heard the matter. So therefore, I just am requesting if it can
we
be
have. And
convenient.
we have also noted down your submissions. We'll decide it today. There is some time constraint. My brother has to sit in
No difficulty, my lord, no difficulty.
another division bench. We will place it sometimes in July.
Lord, if it could be May, my lord, some date. Lord, it won't take much time. It's the submissions,
in
they
July.
can actually consider the submissions and they can also, my lord, give their thoughts.
Mr. RKD Chaudhary, you are appearing for the Union of India. You please be ready on that date. Next day we will hear. And if possible, Mr. Phuken, you can also come in person and come physically and appear. Whatever is the convenient date, whenever you are coming, we will fix a date.
My lord, if it could be end of May, my lord, there's some other matter my lord had
Yeah,
fixed.
I'm asking for a date in July. You are asking us for May. July.
My lord.
Let this
Any
matter
date,
come
my
up
lord. Any date convenient.
किसी समय जुलाई में जैसे ही खुलेगा उसके बाद
16 July.
Obliged, my lord.